Yes, Mr. Bhuya. 20 on behalf of the government. Your matter. Hmm. Hmm. Acha. 20 after 2 weeks. Okay. As prayed for by Mr. S. Bhuya, learned counsel, list this matter. List this matter on 18th of June. Miss K. Devi is present for the petitioners. 10 and 11. Okay. 10 and 11 likha. On what ground? Mm-hmm. Okay. Mr. T. Kashyap, learned counsel for the petitioner, submits that there is some difficulty in doing the matter today, and he has informed the same beforehand. As such, list this matter on 25th of June. This is 2018 matter, Mr. Kashyap. 22. So we will not give you such a long date. List this matter on 17th of June. Okay? Hmm. How what? 32 of supplementary, yes? You are appearing on behalf of? Acha. Okay. Mr. R.A. Sheikh, learned counsel, appearing for Mr. P.J. Fukon, learned counsel for Gauhati University, prays that the matter may be taken up on a later date, which is not objected to by learned counsel for the petitioner. But as such, list this matter on 10th of June. 10th of June. 23. You are there for the petitioner. No, last time also they took time. What do you say? Okay, a short date. Okay, last chance. Okay, Miss P. Das, learned standing counsel for secondary education, submits that the matter may be taken up on a later date. Miss, your name, please. So and so appearing on behalf of P. Bordolo, however, submits that time has been taken off and on by the learned counsel for the department. As such, list this matter on 10th of June. 17th of June. 17th of June, yeah. But upon likhi diya, allowed, the prayer is allowed, but as a last chance. List this matter on 17th. 4, 5, 6, what happened there? Mr. P. Dalugdar. Miss Bora. A. Nath, learned counsel for the petitioner, submits that the conducting counsel has medical issues and has prayed for some time. Prayer is allowed. List this matter when? List this matter on 16th of June. Yes, Mr. Yes. Listing. You please speak to the courtmaster. He'll do the needful. Tomorrow, Monday. Uh, 9, yes. Mm-hmm. Oh, Miss. Okay. R. Saloy, Learned Counsel, appearing on behalf of Miss S. Bhuya, Learned Senior Counsel. Oh, B. Bhuya, Learned Senior Counsel, praised that accommodation may be granted in the instant case. The prayer is allowed. List this matter when? List this matter on 15th of June. Yes, Mr. Mama. Mm. Mm. And there have been enlisted in taking any manner. Salaries of this period of transaction. Acha. So on next year I am doing on detail. Okay. Okay, that will be. See, not many matters are there before you. It will reach. Don't worry. Ha ha ha. It will reach. Number of matters are being mentioned. Mm. Mm. MU Ahmed is out of station, so you want to, yes, heard Mr. PK Bora, Learned Counsel. You are for the State Council? Acha. SF Chisti. Okay. Mr. PK Bora, Learned Counsel for the Learned Counsel, appearing on behalf, no, PK Bora, Learned Counsel, he is also for the both side. As prayed for by the Learned Counsel for the parties, list this matter on 2 weeks. Okay. 12th of June. Hmm. 7. Yes. Acha. Okay. Okay, I'll change the date then. When? You again have to ask him. Acha. So what? 19th? 19th of June. You please inform him. If he has some difficulty, let me know. It is parted before Discord. Oh. Oh, acha. That college, university. Acha. So you have filed your affidavit? Mm. Mm. So last time, why did he get adjourned? Hmm. Oh. Uh-huh. Acha. So what is the actual date then? 6/1. Hmm. Ha. Records are here. Of course, I remember without any delegated power, so they did it. Okay. So Hmm. Mr. Datta has almost finished his arguments. Hmm. Hmm.
principal act. It was made in the plan. And unless and until there are regulations in place, now the authorities cannot function. Not known. But that gives the authority to power. Now, how the power will be exercised by the authority, the content matter which rules or regulations are made. Now, you can exercise a particular sort of a power, which that you or the act may have given, provided there are corresponding regulations in it. There is a case where there can be absence of any regulation.
There are no regulation framed till date under the statute act.
They are going by training, taking resolutions as regulations. Not taking of resolutions, not the vacuum of the legal vacuum. That will continue to exist unless and until you take some decision in pursuance of the rule-making power as given under the statute. The statute gives you power to make rules and regulations. Unless and until you make that, not taking of regulation is of no consequence. That is the case. One thing, before I take the lordship straight away to that particular point, first fact I need to help people. Your lordship and remember that on the last day I say that I was requiring the case was fixed on asking consideration of that was the purpose for which this was cases was. My learned friend's insistence was that nothing will happen. He makes an undertaking that nothing will be done, and therefore your lordship
Yes, I remember.
That was the position. Kindly see, yesterday they have passed an order extending the order of suspension. Despite the concession given by him here, kindly see their conduct. This is the conduct of the what I have been trying to impress upon your lordship from the very beginning, that the authorities in the respondent university, they have not been acting in a manner which is they are otherwise expected to do. Some statements are made before the honorable court through the council. Naturally, I believe that he makes the statement based on the instructions received from the court. Now, respondents give him some instruction. He makes a statement before the court, and they behind the statement, going behind the statement, they pass subsequent order. This is a exercise, I should say. Something they will project before your lordship, and inside the university.
So they have extended the suspension order.
Although it is no challenge the order and also the subsequent action. It's there. That way, there is no reason. But I am only trying to project the conduct.
Their conduct. Okay.
Can you see this? Yes, because there's previous order of suspension, which is under challenge for 1-2. That order of suspension is valid today. And they also know that the order case is coming up today. But they cannot wait for your lordship pronouncement of the order. They hold a meeting in the previous evening and they extend it completely. This is their conduct.
So if first suspension was for a period of 3 months.
And that 3 months was to expire today.
So they have extended.
Seems to go that order of suspension is in the calendar. And you also know that it's coming up today because they have reflected it. Matter is coming up to this for consideration of the honorable court. What is this so compelling necessity that without waiting for the court's order, renew it? And kindly see, the first notification of 12th of May, that is the notification with regard to constitution of the Executive Council meeting. In the agenda, there is nothing that the purpose of amending. In the agenda, there are only 2 things. Discussion of the matter related to fresh court case by so against the university on 5th of May. And the second is any other item from the chair. Now,
so the main is this court case.
This case, this particular. So they were to deliberate upon the strategy that they will make in the case. And yesterday, this has been served to me, the next order, 12th of May. Yesterday, this has been served to me on 2 and emails. So this is how they are playing with the, I should say, they should playing with the, they're playing. It was a remained effort by my learned friend that no interim order should come because nothing will happen in 1 week's time. My apprehensions are proved right.
Okay, we will hear the case and dispose of today. So, Mr. Datta, please remind me, refresh my mind about the facts I forgot.
Yes.
In a brief manner.
Yes. You can kindly see There was an order of,
Mr. From Medhi, you can sit.
there was an order of suspension.
Mm,
It's current, for one.
mm,
Also, there was an order of memorandum of charge,
Mm.
which is in challenging for one.
Mm.
Now I'm just giving, just to refresh the memory, I'm just giving the background.
mm,
2025, I have been working under them as a recruiter. 2025, there was an advertisement for appointment to the post of registrar.
mm,
I was one of the aspiring candidates.
mm,
Now, there was a last date, as it happens with all cases, there was a last date fixed for receipt of application. I noticed some irregularities in the sense that some applications were received beyond the last row.
mm.
So, taking a challenge on that now, that the university is going to appoint some, the university is going to consider this as a third person, where not the applicants by the stipulated date. So I come before this board and make a challenge in a
No, I mean, the allegation was that the applications were wrongly, delay, there was some,
which how the
huh,
that I can
applications for the candidates aspiring for being the registrar.
think
Mm,
just based.
mm,
My subject I was holding the post of in charge registrar. So with that grievance, like come before the honorable court, the honorable court grants me an order of silence.
mm,
That nothing will be finalized as regards the account. The very next day, 24th of November, the order was passed by this honorable court. Sorry, 26. The very next day, they pass an order and take away the charge of assistant registrarship from me. Adopt registrarship from me and give it to the respondent of court. But that order was also challenged by me. The honorable court said that since there was my context was that the transaction of the financial power was not complete, so honorable court's order was that let there be a status quo. Now, in that scenario, they issued the respondent number 4 issued a show cause notice to raising certain allegations that at the time of my induction into service, I did not have proper degree, or I had produced some records which were not genuine, etc., etc. With these kind of things, they
mm,
should have shown us.
mm,
I made a reply saying that I have come into this university. My previous employer was Concordia University. There is another university of that. So I said that I came from that university and this was the degree. And as far as the question of validity of the degree was concerned, I said that there was a litigation in Karnataka High Court, and the Honorable Karnataka High Court had made it clear that for a particular academic year, all the degrees generated by that particular institute will be regarded as valid. And I had also, those are also part of the records here.
So your degree was valid.
That was my complaint.
Mm,
And in support of my convention, I also sent relied on the judgments, which were pronounced by the Honorable Karnataka. When it was at that stage, the appearance that they were not satisfied for reasons known to them, they issued a order of suspension to 26th of.
Only on that ground that your degree was not valid.
Yes, that is one ground. There are some ancillary grounds generated out of it by saying that, because when I came from a current university, so in the new university, I need a paid protection. So my past service to be counted. I produced a certificate from the previous employer saying that the length of service that we counted here.
Mm.
So they also say that
Your service in the Sankardev University.
counted so that I get the paid protection.
Mm.
So by constituting a issue out of there, they say that that certificate was also paid, as if I had not worked in the university at all.
Mm.
Whereas the fact remains that I can be when I updated my application, so it was there. I also take another plea that regardless of the status of the degree, which you doubt to be valid or invalid, I at that point of time was having one more master degree in another field, master degree in IT. In the charge sheet now they say that although you might have 2 degrees, but we consider only LLM.
We consider only
LLM.
LLM.
Because the post of deputies are wanted a degree in master degree holder with 5% of marks.
Mm.
I say that
I also have another MA degree, but that was not considered.
SC in IT.
Mm.
In reply, they say, I mean, in the charge sheet, they say that regardless of whatever you might have possessed at that point of time, we have considered your candidature only on the ground that you are having an LLM degree. And we find that the LLM degree is invalid. Why it is invalid? Because at that point of time, the particular university did not have the recognition of the PCI, Bar Council of India. So, in response to that, I reply that regardless of the issues and regardless of the litigation, that was the verdict of the Honorable Karnataka High Court got once in two petitions saying that up to the academic year 2014, I was a candidate in the academic year 2012. Up to the academic year 2014, the degrees will not be in question. That will remain as it was. It was resolved just like that.
After that year, it was said to be invalid.
After that year, the court was of the best corporation setting.
Okay.
Your lordship knows this nowadays this school, I mean colleges and all, they require to renew their recognition because there are minimum standards changed. I mean, some of the standards are maintained without them.
Gotcha. Okay.
Because now making a, I mean, issue out of it, they should be charged. My concern is that I mean, principle of the substance of the matter. I got it. What's the point of it? It's secondly,
Registrar in charge is response number 4 here. Yes.
he also happens to be a person on probation. Here, just joined the last month.
In your place.
Yeah. And he's on probation because he has not completed with your, I mean, unless and until your lordship told me the probationer applies no right to divorce. Unless and until he is confirmed without no right. Right until the person of the petitioner.
He's in charge, registrar.
Therefore, I question from the as to who can be confident in these circumstances to act as my, I mean, act as my disciplinary. I can sir, on a reference and ready to the provision of the act, and the executive council.
The appointing authority, who is the executive council?
That they require to keeping place, having place, some regulation, which is often what they have done, execution, protection given from the respondent's side. Because without the council had resolution and based on the resolution, EC was authorized to take appropriate action. EC had authorized to register.
VC is Vice Chancellor, yes.
Executive council had authorized, whether that is being appealed from side. They want to give a protection, then EC had authorized the VC. VC had authorized the registrar in charge and consequently the order into issue. So my short and pointed submission is that whether this channelization of activity process is permissible within the act, within the framework of the act. Now, in the act, whether the EC does not possess any power to delegate its function.
That you have shown last time, he has no power.
I'm also relying on a, because the protection last time came, that EC has given the authorization to the EC has in turn given it. Whether I also come, with a section of your Supreme Court.
That sub-delegation is of course not allowed.
Then, the Supreme Court has said, that was a case where EC had the power, I mean, EC had the power of delegation. In our case, the EC had
Nothing.
There, the EC had the power of delegation. Even then, honorable say that this power, unless the delegation is spelled out, that this act can be delegated. You cannot delegate any act of the that is the judgment will not be there. My submission is that this movement, linear movement of the matter will not be there's something the EC takes a decision. I'm not going on the merits of the decision, but because that will be another chapter. EC takes a resolution. EC authorizes the EC, and EC authorizes the register. Now, whether it can be permissible in the framework of the act. Lordship, from the last time I had submitted the copy of the act to your lordship.
Yes, it's there.
Yes.
Hmm.
But the act, Lord, should you kindly see? Section 6(5).
Yes.
5 say, of the word.
Yes.
6(5) says to create such people, administrative and other posts as to university may be necessary for time, and to make appointments there.
To create such teaching?
Yes, so they will create posts for the university.
Mm.
In those posts, the university will be laid upon. So the power of appointment is the university. But who will exercise this power? That power will be exercised by the power of appointment will be exercised by the for that your lordship will kindly see the authorization in the act that will come at page 4784, it will be section 27.
Section 27, yes.
Subject to the provision of this act, the other than the chancellor of the vice chancellor, judge and technical staff, and other employees of the university, and find their duties and conditions of service that shall provide for any of the temporary wishes.
These are the duties of the Executive Council.
Powers and duties. This is the condition of service. I say my categorical statement for the authorities and also the authorities. This defining the condition of service is absent. The reason for this is that the regulations which they are otherwise required to make, that they have not done. About the regulation, they will not see this sometimes to.
There will be enabling power.
Yes, there is an enabling part. The enabling part will also be noticed at page 4782, section 25. Because the top authority is Senate, which we usually call it Senate. For the court. Now the topmost authority in the person is court. The court's power in that section 25. There you will also be 5 clause 3. Approved with or without modification is statutes submitted by the executive council. Now, the scheme is like this: executive council will take a resolution. In accordance with the resolution, they may form a statute for a regulation as they feel necessary. Then this statute or regulation will go for approval to the Senate, which is the court in this case, and the court with or without modification will approve it. Then only it acquires the character of the statute. Then only it acquires the character, acquires the statutory character. So I repeat my last base submission. For us, this the Article Act 2017 is the grand norm. But the grand norm possesses is the repository of all sorts of power. Now, if you want to take some action within the statutory framework, then you have to act in accordance with the provision of the law.
But in absence thereof, this will prevail. I mean, they cannot, since there are no regulation, it cannot be substituted by, there are no regulation, it cannot be substituted by resolutions.
Yes.
So, yes, they should have, now this act is of which year? 2017, they should have framed the regulations.
Just known to them, not they are not done. But I think practically, I can say some words, you kind of difficult say that just like they're sitting in a club. One person saying that this has to be done, everyone nods their head that yes, this has to be done. There is no deliberation. I'm reserving my argument for the
There is a power of delegation here,
but that is only fixed power.
subject to the Vice Chancellor and with the previous approval of the Vice Chancellor, the Registrar may delegate any of his powers or duties.
See, one of they get their power, not the EC.
So,
Interestingly enough, neither of these two authorities are my authority.
appointing authority is the Executive Council.
Yes, that is the I take statement your lordship to be decision below.
There are enabling power for regulations also, but they have not exercised. Section 49. Hmm.
That's paragraph 16. But
Hmm.
paragraph 16 will be that A158. There are also got a question of disciplinary action was involved.
Hmm.
But they are just split from
Yes.
with these provisions, because the provisions have been noted,
Hmm.
around 15 years lordship can issue delegation of power.
Hmm.
In their university, there was power of delegation was noted.
Hmm.
With these provisions, we turn to consider the first question as for the appeal. Question is whether the vice chancellor was competent as a direct disciplinary action against the respondent.
Hmm.
In this context, we will make two general observations about the position and powers of vice chancellor. The university education and financial relations report, because there are some report is closed.
Hmm.
Lordship is over this part and come to para 20.
Para?
Para 20,
Hmm.
page 1.
Hmm.
Counsel for this applicant argued that the express power of the vice chancellor to regulate the work and conduct of the officers of the university implies as well the power to take disciplinary action against the officers. We are unable to agree with this contention. Firstly, the power to regulate the work and conduct of the officers cannot include the power to take disciplinary action from their uniform. Secondly, the Act confers power to appoint officers on the executive council. Exactly in that is the case here.
Hmm.
And it generally includes the power to remove. The power is located in section 20 of the Act. It is therefore futile to contend that the vice chancellor can exercise the power which is conferred on the council. It is a settled principle that when the Act prescribes a particular body to exercise the power, it must be exercised only by that body. It cannot be exercised by others unless it is delegated.
Hmm.
Now, what is sub-delegation law that is called Halsbury law that is noted?
Hmm.
Para 21, the council for the estimate may submitted that executive council in the instant is that delegated its disciplinary power to the vice chancellor and the act provides for such delegation. That is,
There the act provided, but here not.
so this is the answer. Here the answer comes to our
Hmm.
para 22 year lordship and this is next. This resolution in our opinion is basically for at least for 2 reasons. It may be recalled that the executive council, without considering the report of so-and-so, wanted the vice chancellor to take a decision thereof. They also noted that the vice chancellor was present at the meeting of the executive council when the resolution was passed. Was given full power to take a decision which in the context was obviously on the report of so-and-so and not on any other question. About one. The opinion, the power delegated under the resolution and the vice chancellor could either accept or reject the report with information to the executive council. He could not have taken any other action, and indeed he was not authorized to take any other action.
Hmm.
So it was said because in a situation where there was a power of delegation, then also the court said that unless the power is delegation is very specific, you cannot. So the disciplinary action was set aside in that particular. My case below this below. Unlike the case in that, here there is absolutely no power delegation. If you want to have power executive, then there has to be statutory amendments made, because the Act makes a provision that if there comes a situation where there will be conflict, it has to be referred to the state of Assam.
Hmm.
Because state of Assam is the open to where the
Hmm.
unless and until those exercises are done.
Hmm.
You cannot simply take and adopt some resolution and pass it on as a
Acha, which was the provision you showed for appointment of teachers and all? Executive Council.
that your lordship find at the
6. 27-6.
yes, 27.6. And 27 alongside your lordship has seen the power to make regulations.
Huh. That I've seen.
This condition itself, your lordship will find the first statute of the university.
Hmm.
But in that state, you know, nothing as regards the power of, the power of accounting of operating or distribution of the these are the operation. Nothing. It stopped at registrar and the accounts officer alone. It did not go further. So if you want to do some act, to make the regulation, put it in place, get it approved through this election. Then only you can take an exercise.
Okay. These are your submissions?
So, with this submission, I would say that in the affidavit filed by the respondent, they particularly in your referred to annexure C and A is at 205 and 206. So they have referred to these two pages to show that it was right, the vice chancellor and the vice chancellor and that. That's the new concept.
Where is the resolution?
The resolution they have placed at page 100. 140. But the last page is 242 and 1 change the loss to 549. And the registry document, that is a very complicated thing. Your losses are also moving the last time. At one break, they say that I did not have any valid degree. On the other break, they say that I was having only degree level. That kind of confusion maybe it's just
as far as your degree and all are concerned, that is in the merit of the case. But your main contention is that the registrar, the in charge registrar, could not have issued the memo of charges to you. And suspension order was passed by registrar in charge, so he cannot because he is not the appointing authority.
And secondly, they also not have done it in the manner that they have done because there are no regulations in place. Their only case is that in the
EC, without the regulations in place, EC can do it because he is the appointing authority.
Yes. Now, to take a decision in the EC meeting, they have said that we have adopted the provisions of the disciplinary services service and ethics rules 1964. Now, if you adopt that particular rule, then necessarily the procedures prescribed in that rule
has to be followed.
Has to be followed with reference to the positions that you are holding. Because the disciplines are service and ethics that equalizes at least 3 operators. One will be an appointing authority, one will be a disciplinary authority, and one will be an appellate authority. Now, if you are acting as an appellate authority, you must also define who will be the appellate authority. You must also define who will be the
disciplinary
authority.
Those things are not done.
Because those things, they have to frame a regulation. Merely because the EC has adopted a resolution that they will proceed against me, it will not acquire a statutory character. Their resolutions will acquire a statutory character only when it comes in the framework of the resolution. What is the, if I can just explain it this way, the cabinet takes a decision that we will do this for the purpose of doing this kind of things, we will do this. Now, the translation of the opinion of the cabinet finds approval through the statutes that they make, the elections that they. So, merely because the cabinet has taken a decision, it can be an executive decision, but it does not acquire the statutory character, so to say, that it will be in exercise of the ruling power of the 309 or some other. It will not acquire the statutory character. Statutory character will require the statute to be made. If you public in the official, then only from the day of publication it comes.
No, by adopting 1964 rules, without the regulations, those provisions can it be covered?
You are simply adopting the rules. You are also required to today, if you say that by adopting the rules, I want to act as you also need to ponder upon the point that will be the appellate authority. Suppose you take a decision against me. Is it a reaction? To whom shall the appeal lie? Because in this structure of the university, EC is on the crop.
Senate is there.
Now it has to be specified. Now, if you are, because exercise of what is the purport of this decision which I have said, that the disciplinary action is a statutory action. It is not an executive action simply. Therefore, the Honorable Supreme Court has said that although you may have the power of delegation, but it will not require the statutory character because it's a statutory function. Now, here also, if the 1964 rule is to be applied, then it's a statutory function. Now, a statutory function cannot be done or undone by somebody in a void. If somebody wants to apply the statutory power, then there has to be corresponding provisions made in the Act. Now, in the Act of the present time, because there is none. So my submission is that they will have to, they ought to have framed the regulation well in the past.
Acha, what does this resolution say? 242?
Resolution simply says
That in charge registrar is given the power.
no.
Where?
I'll just
249? 8. Validity of the appointment of Shekhar Kanti say.
Concerned about the misconduct of the activities of so. After detailed discussion of the report submitted by the chairman and the so, members of the executive council are of the opinion that the appointment of so and maybe we should be to leave those anyway. The post of so which happened in the year so is under question as if LLM degree is reported to valid. And at the time of joining he had only LLM. Now this is confusing again.
Achha.
I'm not saying that it is valid and you are also saying that I possess only that.
He had only LLM degree as his PG degree. At one point they say it's bad and then they said he has only this degree. Acha, let him finish. We will come. Moreover, the experience.
It's the kind of way they have been doing things. And interestingly enough, because they are doing it as per the legal opinion. In the subsequent sentence, it is clear. Moreover, the experience certificates from Mohapuru for the university submitted by so based on which his qualification post of professor was considered of so are fake. Now they are forming the opinion that these are fake without there being a disciplinary inquiry. If you have already formulated an opinion that it is fake, what is the purpose of the inquiry?
This is prima facie opinion.
Qualified that way.
Then also his
PhD from Assam University. Now, this petitioner is a doctorate in law. Also, his PhD degree from Assam University based on LLM degree distance both from Karnataka State Open University is also under question. Now, although they say it is under question, they do not make a charge on that ground. Dr. So-and-so,
no. Therefore, the House unanimously.
Taking legal opinion from the standing council by issuing law. Now, my learned friend will be best to say what legal opinion he gave, but thereafter, the lordship will find the resolution by which they have said that we are adopting the positions of the Assam services. That your lordship is there.
This resolution was by the Executive Council by holding a meeting. This was on 6/1/2026. 254, yes.
54. Second House unanimously, that is dated 25th of February. House unanimously resolved that the inquiry in the matter should continue by being so-and-so under suspension as the disciplinary proceeding is conducted strictly in accordance with the suspension. Now, this adoption of this particular service disciplinary action was done in the previous meeting.
The registrar in charge is authorized to issue all communications in consultation with Vice Chancellor, including issuance of suspension order. He is authorized by the Executive Council.
Now, in the charge sheet that has been issued, charge charge sheet that has been issued,
Mm.
the charge sheet, he writes himself as the,
Mm.
I support the inquiry, that is the wording of the paper. Now, case 243,
Mm.
the lordship is writing by
Huh?
saying for the
Mm.
the Antasada relation of the
Mm.
adopting Assam civil service role should be ruled.
Mm.
Appeal and discipline, that is also a cost type of a thing. For teaching and administrative staff. Secretary to the executive council so bill before the house, the copies of so for consultation of the house.
Mm.
After detailed discussion, the house resolved to adopt so for Rabindranath Tagore University. Now, this becomes a legislation by adoption in that case.
Mm.
Now, if it is to be a legislation by adoption,
Mm.
then it has to be incorporated in the statute. That's why I'm saying that that a regulation has to be made merely by your, because the act does not give you any rule-making power.
64, this act.
It's RTU Act
Mm.
7.
Mm.
Does not give any rule-making power to you.
Mm.
To unilaterally pass it, because you are, whatever regulation you will frame, that will have to be placed before the court.
Who will approve? Mm.
Then only.
No, that is regulation creation, but this is adoption of the 64 rules.
Then also the this adoption, this act of adoption has to be authorized somewhere in the act, principal act. Because in the principal act, what are your duties and powers? These are outlined.
Mm.
If you are in the powers and duties outlined in the act, it nowhere says that you can adopt a position of power.
In case of 6 schedule areas, they adopt. Right. In case of 6 schedule areas, they adopt such acts. It is enabling, yes, and there is an enabling power.
The house approves.
Mm.
Then only it gains the character of statute.
Mm.
So here also, Lord, what I am saying, if the resolution is to adopt the provision,
Mm.
then it is basically for the court. Let the court approve it. Then you are putting the horse before the cart. Putting the cart before the horse. Let the resolution be adopted. Let the act, discipline rules of 64 be a part and parcel of the RTU Act 2007. Let the Senate pass it. Then only you can act. Otherwise, because that is the purport of the.
They simply adopted the rules. The Executive Council.
Inconsequential. Because if you adopt the rules, you must also necessarily provide for the authorities prescribed under the rules. Because in 64 rules, your lordship will kindly see.
Mm.
If I take your lordship to the position of
Services can be some services. $. Mm.
I take your lordship to the position of section 2.
Mm.
Section 2 says,
Page? That will be the same page.
This book is
531. Asa, some appeal and discipline and appeal rules, right? Mm.
Section 2 parts here also. These rules, unless there is anything defined in the subject or context.
Wait, I am yet to take out the rules.
Hello, your lordship.
No, it's okay. What is the page number you said? In this book, yes?
Or your lordship can take this book, I will hand it up for me.
No, it's okay. No, I'm not getting any contents of discipline. Discipline and appeal rules also. Yes. Discipline and appeal. 426. Yes. Yes. Appeal lies.
Appointing authority in relation to a government servant at any particular time means the authority empowered to appoint any post which he is holding at that time.
That will be okay, Executive Council, but whom the appeal lies? Is it provided in the Act where the appeal will lie?
So I am saying, Lord, it has to be on putting regulations.
So without the regulations, of course, the operation will be difficult.
That, yeah, well, that is common thing, that we all know that Act gives you power to do certain things. Now, how you will do it, that is usually provided in the rules of regulations.
And it is provided here under what section? It is provided under section 49. Subject to it, it's similar like perimeteria with other provisions. So they have to make, anyway, there are no regulations in place now. We'll have to go for whatever there are. So,
Now, first you there is always a function of appeal in every sort of goods, that function of appeal. Now, if you take a disciplinary action against me and I do not know to whom the appeal will lie, then I will render damageless. Within the provision of the statute, I have rendered damageless.
anyways, here is the case where you have challenged the suspension and the memo of charges
Yes.
being issued by a wrong authority.
Also on the facts that this particular fashion of working is
Not tenable.
not tenable.
Okay, that is a different issue, like for making regulations and all. Let me hear him. So, what does he say? Yes.
My own, there was something in that. The lordships will interfere with these two orders. Because apparently, Lord, these are very offensive. Secondly, Lord, I cannot conceive of a situation as an officer of the court, Lord, I cannot conceive of a situation to suggest that there cannot be no action against. If the authority has felt that there has to be some action against, that's illegal.
They'll have to do it by following the law.
Let these two orders go. Let them take a call as to how. I cannot advise them as to how, because they have a legal person to advise them. They will frame appropriate rules and regulations as is possible under the Act. There are the actions that action give this whole field. There are the actions that may continue against, but not in this. That is my son.
Yes, Mr. Methi. Make it short and precise. No, not even 1 hour. It started for you. I give you a short time, please. I've already heard you. Haha, you continue. These are issues of law. You need not have pleadings for that. Mm. Mm. When he was in charge registrar, what? Acha, yes.
Office of the register, yeah, some indirectly there is some direction not to receive the case. But there the only I have already started to one of the service here. There are the November itself, he made an idea taken on one person, another person. That is, it was concerned that it was for a post postal. But in short term, there is no such postal delivered in non-recipient university, and he on to 25/11/2025, he gave a reply that the report was prepared on August 30. 30 August, 4% is there. So
I'm not able to get your point. No, I'm not able to get your point. Tell it clearly. When he was in charge registrar, then what happened? There was an advertisement for the post of registrar. During that juncture, he was the in charge registrar. Acha, he gave the direction not to receive? Indirectly, okay. Ah.
Side also, the one dollar could directly to produce the application basic those particular tools.
So after that date, applications cannot be received.
See, so what happened is we filed a card by one unknown person. We filed an application before the university for the for supply the documents to submit the application on the 30. But there is an event this came to know something was happened directly from PC application. So his application RTA application which was filed by another person, it was although shown in the postal service, it was there is no trust record in the postal service as well as the university also did not get to receive. So he ultimately he gave reply. He was the RTF from the procedure public information officer. He gave reply on 25/11/2025. That was on that it was RTF from the receipt on November. But report was prepared on 30/8/2020. In August month, the report was prepared, and it said application number which are so-called RTA application. It was
And these are not required to be.
then they have to
He filed a writ petition that I know that saying that applications were received even after the date. No, first of all, you answer whether the in charge registrar is the proper authority in issuing the suspension order. By virtue of that resolution. By virtue of the statute. Show me from there. But then he wrote I under so and so, that language. From where do you show he is the issuing authority except the resolution? 1/6. Yes. Acha, let him show. You are showing from the act? No. It's okay. Page 2. 241A. Okay. Hmm. This is a part of the act. 4.2, 4.14, can it be a part of the act? I have this. Oh. আচ্ছা, statute খন দিয়কচোন হেমেন্দা, statute খন. The registrar shall issue the appointment letters to the teaching and non-teaching staff in terms of the references as approved. Where? From where are you showing? 240. 4.2.4. Yes. 0.8. The registrar shall represent the university in the court of law in suits and proceedings. That is different. Shall be authorized. Acha, the registrar shall be the authorized officer to sue any party individual on behalf of the university after due approval of so and so. So you are, you are taking the power from here. This is 238A, yes. That is section 16. Mm.
Maximum.
No, she can sign, verify all appointments on behalf of the university. That is okay. Mm. 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 Mm.
And when
He's just a signatory. He signs.
the resolution,
Mm.
outside natural hospital,
Mm.
in my activity page 49, here from start 248.
Mm. No, no, yes, I have seen that. He had placed. Mm. Mm.
But the condition is here. Usually related to
Mm. Mm. Mm.
His house expressed serious concern about the misconduct and for activity of others.
I've gone through Mr. Mehdi.
And we took submitted,
Mm.
submitted under addendum number 5.
Mm.
Addendum number 5, not addendum number 5 from the Lordship may go to that.
Chairman means what chairman? This is what chairman?
Yeah.
Oh,
Then
oh, okay.
Lordship is addendum number 5 by Lordship internal.
Mm. Page?
Addendum number 5 start 44. 44.
Mm.
And relevant page 45.
Mm.
Last page, which is the improvement and so and so. Separate and circular subject and tell them market of conduct.
Now, which 245? 245, which part are you reading?
It's
Hmm?
last 248 last H
245H. Okay, yes.
circular subject tell them market of conduct of university without supporting community pride and and we will write all from the rest of my beyond 2012 due to non-compliance.
It's okay. These are on valid LLM certificate and all. No, what I can deduce from your argument is that the registrar, the in-charge registrar, was just a signatory. He had issued the memorandum charges as well as the suspension order, but the decision was of the executive council.
Yes, yes.
Mm. This is what your answer. Then go ahead. Mm. This is what your answer. He has simply issued. Mm. Mm. Mm.
Under question, as his earlier meeting is reported to be invalid, and at the time of joining Regional Public University, he has only LLM degree as his PhD degree, which is essential qualification for a post. Meaning their mind, only this degree submitted application only shows LLM degree. So that is invalid. So this sentence meaning of this sentence.
Mm. The only LLM degree he had is invalid. The only LLM degree that he had is invalid. This is what is said.
Yes.
That was invalid. Mm-hmm. Maybe you didn't understand what I said. I said that. Yes.
Yes, on which his qualification to the court of the state was considered in a 2023 by the University of Tech. Also, basically from the Islam University based on William degrees and in distance for William research and from the Contact University, not University also. Why issuing notice? So first, initiating different processing as per law. Instead of consequently trying to license the appropriate step particular by the law in this as chairman of the executive council so as to maintain the sanctity of the university. The licensor is the chairman of the executive. So he is not very far. So here, my lord, the next my lord is case 240 245.
245, yes.
So 254.
254.
And last is House Congress resolved that the inquiry into the matters should be continued by putting the court and the circuit under suspension as dependent proceedings contemplated. Strictly in accordance with the provision of Assam Civil Service, so maintaining transparency, integrity, and dealing from procedure compliance at every stage. Register itself is authorized to issue all communication in consultation of vice chancellor, including issuance of the suspension order, memorandums of consent. He is also only last like this issue the appointment letter. Yeah, going that the petition reporter registered and he issued the person. He is also he is authorized to issue memorandum. Maybe with the sentence may be different. On the ground, I don't want civil or interpretation.
Then?
And chairman to price.
Mm.
And it's 255.
Yes, 255.
As far as the numbers, 25 February, the suspension order of
To the what? This is a letter by Vice Chancellor to Registrar in charge. Okay. As per EC resolution, the one you have shown, this is the one. 6/1/2026.
Yes. February, the suspension order of the second party has been approved. In 6/1/2026, the EC and by chairman of the Relief Council is authorized.
Acha, you did the one that you have just shown.
Yes.
This was dated when?
59. This was 6/1. 6/1. This 6/1/2006. This was chairman is authorized. Chairman, I think chairman will authorized
EC resolution dated 6th of January 26.
Yes.
But this is 6th of February 26. And on the basis of this one, page 248.
48.
This is the problem that we had faced on the. Yes. This was meeting on January. 6/1. But then how come this will be 6/2? This should be 6/1 only. Or record shows it is 6/1. Then the meeting is on 6/2. 18th executive meeting held on 6th of January. And then how come these resolutions are. Number makes a difference. See, the House unanimously confirmed the minutes of all the 3 meetings. Approval of list of graduates examined for conferment of 28 January. Resolution number so and so dated 6/2/2026. And the meeting was on 6th of January. How come 1 month later? Hare, number of the resolution is there, but along with that date is also there. It should have been 6/1. All. Record says what? 6/1. Then what is the purpose? Same things are there. Yes.
The signed by the vice chancellor is 6 months conference. So that is only the number to the university.
Not number. This is a date which is wrongly put.
Yes.
Why are you saying number? Number is there. But then date is wrongly put.
Yes.
Okay, we will consider it as January. 6th of January 2026. Resolution number so and so dated 6th of January on the basis of EC. On the basis of EC resolution number 25 to 2026. Where is that? 20.
It's now
254. Acha, this is on 25th of February. Okay. There, the resolution for suspension was taken, no? Acha, and on the basis of EC resolution, suspension order of so and so has been approved on 26th of February 26. You are hereby authorized to issue suspension order of Dr. So and so. Okay. And VC has the power to delegate his power. Mm. 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 Where? Yes, Executive Council authorized the Vice Chancellor to take all appropriate steps permitted by law in this regard as chairman. And then after this, Vice Chancellor has delegated it to the Vice Chancellor has not delegated his own power. He cannot sub-delegate. He was. But there is no power of sub-delegation.
And he first reported himself registered his appointment privacy. Upon the conditional appointment issued by register, it was accepted. The advertisement issued number issued by the register itself was as per the FI.
No, wait. Under the Act, you see the delegation power subject to the Vice Chancellor.
Other word.
He can issue appointment letter. This is section 16, right? Section 16 to sign, verify all appointments, contracts, and so and so. But appointments will be done by the Executive Council. Wait, Executive Council. This is subject to the provision of this act. It shall appoint the officers, teachers, office, technical staff, and all that. So Executive Council will appoint, and a registrar will sign and verify all appointments. Hmm.
My mind is next vaccine the register academic these are the minority member. And so far membership register and vice what's of the inside register is the register. So it's register is such this concept sign matter. So here also might be his authorized matter. Council.
Hmm. What is the prayer here? Quash the memo of charges being illegal, unauthorized, so and so-called disciplinary proceeding. Decision of respond number 4 is the registrar. Acha, contain letters. Okay. Okay, I've heard you enough. Your simple argument is that the decision was taken by the executive council to suspend or to issue memo of charges to start disciplinary proceeding. Registrar had only signed, although the language is different that I so and so. This is all, and this is only on the. I'll not go into the merit of the case, only whether the registrar is the competent authority to issue the memo of charges as well as to put him under suspension. I said that. You don't have to repeat it. Now, what is the judgment? Hmm. 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 Hmm.
Yeah, it's so-called mirror. And when we discuss about
House. Hmm.
in that particular and this is what it is on power and not impeding. So this person of ours.
Acha, where is the suspension order and memo of charges? Page?
The memo of charges at 74.
Page 74, yes. 24/3/2026. In one of the case, we have challenge suspension in one memo. Suspension order is in is which place? 2412? Page 71. Page 71, yes. By Sandeep Ratna.
As I submitted at the beginning, because that the suspension order was expired today.
And it was extended.
So yesterday there is. Suspension order was not there at the beginning of the today was the last day. If you do not extend my last that will not visualize the registration. Because one of this, what happened, one of this, 26 and then 90 was put completed. So it is decided that they respect all the minorities, government force or whatever. They are the not simple to the entire informant. And so far as the suspension is concerned, it is from the it is from the subordinate party also. It will not go because it is appropriate which they council. The so-called is the I have to sustain also it is regarded. Of this physical address will be final.
Ouch.
And suspension matter. Provided that period and order of suspension is yes.
Where, which rule? Wait. Discipline and appeal rules.
Yes.
এটা একটা মার্কেট বলে wait yes, which rule you are showing? Rule 6, yes, suspension.
Or any other authority which is support which is supported or any other authority empowered by the government in the made clear to the government servant as under suspension.
So there has to be a there has to be a what authorization by the governor.
Yeah. Particular post is required to have the other responsibility funding. But discipline proceeding against is conducted for pending, where the opinion of the authority has India himself in the active vigilance of the state, where a case against the criminal sanction, provided that where the order of suspension is made by an authority or the appointing authority, such authorities say, before the appointing authority in the Sarkar, which the order was made. So if you after matter the issuing the suspense also inform the open particular right, then also it will law provide to you. We are on our case matter and the
But your adoption of this rule is also not proper.
first matter. There are two other not from government of India, not from India or authority. So the adoption question regulation and the adoption is different. So my understanding the regulation there's new frame, everything will come. So we are the state neighbors, it is some fair.
Hmm.
And other thing is so far the point of view India is going to disciplinary proceedings against the dictator is done. Where they can there is a score censor court man. There to read court is there available man. So it is not he is not political man. He is a provider of fighting them. So he may
That's okay. Mm-hmm.
so here but I'm not fighting of also suspension of again and the appropriate is then local. Here is there is some 25/5/2006 itself the approval was given for suspension. So for I mentioned madam.
It's okay, Mr. Mehdi. What is the judgment you wanted to give?
But if suppose he replied, recent judgment of this honorable court. Kumar Singh versus
Yes.
yeah, so it was a question that the three different parties.
Paragraph.
After polls being agreed to the member service, the litigation has challenged on the same on the two grounds. First, the ground of the delay 11 years of member service. Secondly, on the ground of person has not been approved by the President of India despite of the application improved emphasis. Here, what according to the system is required to approve. In our case, the council already approved for the discipline person. So this bill honorable court, my lord. Paragraph 5, 6, my lord. Is the association with my paragraph sometimes there is no proof of finance minister initiated from decision proceeding or given appropriate of the trustee. In addition, secretary proceeding usual illegal and to be set aside. On the other hand,
These are submissions. Take me to the relevant part.
Paragraph 11. Which statement response whether the finance from the minister has given appropriate reason and first spend against the research. It is quite apparent that we can want to see the sentence of the concerned minister of the state on a high appropriate the department service. We are look at the state issue can also decide by inquiry officer you must have the concerned file or not to documents can be shown to the petitioner department. Further, we are of the view that instant award of service does not give the right any cause of action to the petitioner to file a litigation under no right of the future petitioner has been decided of the member of service. So, we are not the only the same they put register inside the price since the member of service by the visit council as a he was given the approach so far as member of service because everything was discussed in a visit council. The register itself himself and
Acha, Mr. Datta, you said that as if he has himself issued. But the language is not that. Let's just see the suspension order. Uh, this is let's see. Here 71. Where is her? No, no, the suspension order I'm talking of first. Mm, hmm. A show cause issue was noticed.
Now then, but under which
Mm,
insurance is placed by placed under suspension that shall remain under suspension and further order.
mm,
Now, these seats is conceivable the exercise implemented or any person authorized by the government.
mm,
Where is that? You are issuing the registrar in charge, you are issuing the order of suspension.
mm,
Now, looking at you from this submission that everything was approved.
mm,
What the EC had approved? EC had approved only the issuance of the charge sheet.
mm.
Now the charges were not framed by the EC. In the resolution which they have submitted for your lordship, there is no resolution authorizing anyone that these are the charges on which he has to be disciplined.
Now, those particulars, those details are not there. But then, disciplinary proceeding is contemplated.
Now, who will frame the charge? I assume,
Hmm.
I mean, my arguments made in the first article. I assume that you can proceed against.
Mm,
Who can frame the charge? It is only the disciplinary authority who can frame the charge.
mm,
Because disciplinary authority has to apply its mind to the facts and circumstances and then come to a decision
mm,
that a charge has to be framed.
mm,
Now, the proceedings which have been filed before the honorable court,
mm.
in the resolution, there is no whisper as to what will be the charge, what will be the tenor of the charge, whether it will be a charge of charge under Rule 9, that is major offences or minor offences, nothing.
Mm.
So naturally, therefore, it cannot be justified that the registrar had issued was only the issuing order. It clearly shows that I propose to hold.
Where?
In 74, your lordship will see.
74.
There is one.
2411.
Yes.
But I'm holding 2412
For one is the registrar in charge suspension order.
suspension order.
For double one is the memorandum of charge at page 74.
Huh. But in this suspension order, there is nothing like I put you under suspension or something, right?
It also does not say that the on being authorized by the
Hmm.
ECI.
Nothing is said, but only a disciplinary proceeding is contemplated.
General assumption that I draw
Hmm.
is that it is by the authority who has issued the letter.
Hmm.
And the presumption gets strengthened by the fact that in page 74 memorandum of charge, he says that the undersigned the registrar himself proposes to hold a disciplinary proceeding.
Acha, wait. This is memo of charges 2411, which page? 74, yes.
The registrar in charge proposes to hold a department.
Hmm.
Where is operating? I take a pause here.
Hmm.
The lordship knows that a suspension order can be passed only in two circumstances.
Hmm.
Number one, when there is a disciplinary proceeding in contemplation,
Hmm.
and number two, when I have committed some grave offences of
Hmm.
criminal nature, or I am under some police custody and all. These are the only two circumstances where suspension order can come. Second one is not the case. The first one is that there has to be a disciplinary proceeding in contemplation. Now, who will contemplate the disciplinary proceeding?
Hmm.
You cannot contemplate the disciplinary proceeding against me
Hmm.
because you are not my disciplinary authority.
Hmm.
So consequently, you cannot also issue this order of suspension.
Yes. Okay.
Clearly show.
And what about the judgment that he had shown that memo of charges? Even I did not go through, but one line is creating difficulty. Issuance of charge sheet does not give any rise of cause of action to the petitioner to file a writ petition.
if the five facts are quite different because I am challenging the authority.
Mm.
Because I am saying that the authority which has exercised the power is not conceivable within the framework of law, particular act. You, the regulation 49 is very clear that for the purpose of carrying out the objectives of the act and the legislation of the wording is very strong here. I just read the wording once again to
Subject to the
subject to the
provisions.
provisions of this act, statutes and ordinances, each of the authorities of the universal may make regulations consistent with this act, statute and the ordinances for the purpose of carrying out the duties and for exercising the power assigned to the authority concerned under this act. So if you have been assigned the power to act as something, so you have to frame a regulation to pursue that activity.
Okay.
Their case is that, you know, their EC is all, you know, EC is chairman of the EC. EC is the omnipotent, all powerful, everything. EC has said that I am authorizing. What is this resolution? EC as the chairman, he authorizes himself to act as the authority. As a
might from chairman saying like the council. Exit council after the chairman might. Chairman is the only one person. There's so many persons there.
It's okay. It's okay. I'll deliver the order in the chamber because here it will take time. Mm.
This one depend. Is another. Again, position has been
Paragraph 4, yes.
The removal dismissal of a delinquent and misconduct on misconduct not by the authority, not given the not appointing authority. Minor, here minor dismissal. Here not dismissed minor. Charge was granted. And on the misconduct and must be of the authority not below the appointing authority. However, it does not mean that disciplinary authority may not be initiated against the delinquent employed by the authority, lawyer and the appointing authority. Here, if he may not give if he suppose against dismissed from service or otherwise he some punishment is given by the authority. Then he will put investment. Here nothing is there. So this party here the dependent also speaks by this already dependent authority, no doubt, but the law and dependent authority, but because not by the approved by the appointed authority has no knowledge, no approval. Here appointed authority in every state approval is there. So
Okay.
you know, and another thing is so far suspension is concerned. Suspension might be lordship to nothing because of this. It's not there any punishment. This for dependent on
Yes, yes, that is not.
Results number 25, February 2026 for Friday, easily considered. So suspension meant to mere engagement is certain
It's okay. It's okay. I've heard you enough. It's okay. I'll deliver the judgment in a day or two. But now, if I dictate, it will take time. So I'll take up other matters. It will. Huh? I'll come back in 2 minutes' time. Huh? Other councils I'm saying. Yes, yes. That is a submission. I know. Dispose.
serial number 16. These are the petitions. And against them, the remark has been the opinion has been given that they may be considered for Now, if your order comes to page 104.
From director to secretary.
Yes. From director to secretary, in respect of these, after these views, were placed before the joint committee. Now, joint committee, if you find the third paragraph. In this regard, the below mentioned cases have been discussed in the subsequent joint meeting for provisional.
After independent committee. Again, joint committee. Unlimited authority.
The ventilation for having been into the the necessary action have been initiated as per recommendation of the joint committee.
Hmm.
So there were 5 cases
Hmm.
which the were sent to the government for consideration.
By the joint committee. Below mention has been discussed in the joint committee. Hmm.
It has been sent for
Hmm.
now, if you look at come to the down below the table,
Hmm.
in this context, it is stated that the cases pertaining to remaining 15 incumbents are yet to be placed before the judge.
Hmm. Hmm.
So here, whether the petitioner's case are yet to be placed, so that's placed the instruction now.
Hmm.
Based on these instructions are placed.
Same instruction or these are different?
Different.
Uh-huh. So 26.5, which one should I take up first?
If the person,
Say, all are same dated. Hmm. Okay, with reference, I have the honor to inform you from the director. It is from the secretary.
it is from the direct.
Secretary? Oh, highest director, secondary. I have the honor to inform upon receiving a report from the. Then shall
Nepali Victoria College of High School
was verified.
was verified and found that feasibility report in respect of subject Nepali in Suetso was issued on or before 1/1/2006 by the complainant. Well, this is one of the eligibility criteria under section 3 of the Act.
Acha, why this cutoff date 1/1/2006? Acha. And what no feasibility report means?
Feasibility reporting that is the government accord permission. The permission is granted to the subject
Hmm.
on the feasibility report of this. And in that permission, the subjects are mentioned. So in respect of this subject, there was no such feasibility report given by the SEMA.
So not recognized rather. Nepali as a subject there in that college. Placed
The
before.
matter was placed before the verification of the committee of 2 departments. This is the joint committee.
Joint committee. Hmm.
And the same committee appointed the government of Assam has opened 2 new portals for provincialization service of laptops, and incumbents should apply to the production. Now,
So he has to again apply. His case was not considered because there was no feasibility report. And what does the second instruction say? Oh, same.
This subject
This is Nepali, this is Assamese, and this is sociology. So all the 3 writ petitions are in respect of 3 different subjects. So, Mr. Bhattacharya, the instruction is that you have to apply again, you have no feasibility report. Right. In respect of other 2 also no feasibility report. Not required. You.
there are
Mm.
that was completed by the law.
That was submitted by the council to the government. The council means the. Okay. He will file and reply, he said.
We'll file our reply to the attack.
Hmm? Otherwise, you see, there was no notice issued and only on the basis of instructions, there was a endeavor to finish up this matter. So you can tell something on this instructions now. Otherwise, again, they will file affidavit, they will file reply, things will carry on. You said that there is feasibility. Then you say on that, you say on a different date then. I'll fix it up next week. Yeah, instead of all filing affidavits, they will take long. Hmm. Ouch. Okay. Heard Mr. A. Bhattacharya? Uh-huh. Yes, yes. You give him copies of instructions. Heard Mr. A. Bhattacharya, because I have seen this affidavit business takes long. Heard Mr. A. Bhattacharya, learned counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel for secondary education. Uh, by this application, the petitioner has prayed for provincialization of his services. During the hearing of the instant case, the Mr. Kaushik has placed 3 instructions. Kaushik has placed 1 instruction that is 1 kori tutor diva. 1 instruction which says that the services of the petitioner could not be provincialized in view of the fact that there was no feasibility report in respect of the concerned subject. And the said instruction further says that the verification committee had a meeting and it was decided that government of Assam, it was opined, Bilidia, huh? And it was opined that the government of Assam has opened 2 new portals for provincialization of the services of the left outs and that the incumbent should apply through the same. In view of the said instruction, Mr. A. Bhattacharya submits that he may be given some time to respond to the same, that is to the that is to the absence of feasibility report in respect of the said subject. Prayer is allowed. List this matter on 9th of June, or will it be too late? 5th of June. 5th of June. But then that is subject also. Okay, same in respect of other two. I have not said Nepali, right? Oh, okay. 29 and 30 also. Hmm. ঠান্ডা হয়ে গেছে হাত এখন এসিটা বন্ধ করে দিবা হুম yes হুম আচ্ছা আচ্ছা so cost title file হুম আচ্ছা not shown uh, so let the registry correct that in the CIS. Otherwise, what is the procedure? Name has to be included here by hand or what? Amended cost title, there will be a 2 pages. This is not here. This is not here. But the amended cost title has not been received by the section till today. The office notice 25/5, yesterday's. Oh, so for implement, as such, the name could not be incorporated in the cost title. So there was some defect. So remove the defect. Removed. Okay, heard, Mr. H.A. Talukdar, learned counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel for secondary education, for elementary education. By the office note dated 25/5/2026, it is reflected that the that the amended cost title was not received by the office for implement of respondent number 8 and 9, and as such, the name could not be incorporated in the cause list. Full stop. The learned counsel for the petitioner, however, submits that there was a defect initially in the amended cost title when it was filed, but the defect has been removed and that the necessary correction should be made by the registry of this court. Accordingly, registry is directed to include, or registry is directed to do the needful. List this matter on 29th of this month. 20 notices required to be issued 29th of May. But tomorrow is a holiday. Oh no, tomorrow it's not. Yes. Mm. Mm. Petitioner is 86 years. Acha, matter can be taken up for hearing? Hmm? SCRT. So who is the counsel for that? Or B Gogoi, call Mr. Buddha Gogoi or P Nayak. Hmm. After some time? Or no? Achha, okay. Hmm. The issue is for pensionary benefits. Okay, so what happened? Hmm. Why, item number 3. But pension and the elementary education are shown. Oh, SCRT, yeah. So, okay, they are not prepared, it seems, right? They have not gone into the case. But then, okay, they can, they are seasoned lawyer now, they can aram se say. Because the person is 86-year-old. He should get the pension as soon as possible. If at all he is eligible. Where is the affidavit? Affidavit is there. A short affidavit is there. So yeah, but they can do it now only. Tell them. Call Mr. Buddha Gogoi. He can do it. Okay. Yes. So he was appointed as the principal of a training college. He was appointed as a principal, or he was earlier an assistant teacher. So he was selected and appointed. Then, where is that annexure? Page 14. Okay. Kanan Bordoloi, he is the petitioner. Is appointed temporarily as a whole-time principal of Mongolda Teachers Training. Okay. Hmm. Wait. She's a lady. Acha, so she was appointed in on 25 474. And then she retired 3597. Okay. Hmm. Okay. So 11 September 98, provincial college provincialized. She retired before that. Hmm. Along with the teachers. Hmm. 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 Prior to the provincialization. Hmm. No, no, what does it say? It says the past services of these, where you are not there. So it will be counted towards, okay. T- ah, shall be counted as qualifying service for purpose of pension. Hmm. 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 Yes. No, no, I'm not able to get it. What? Phase 17, yes. So retrospective effect for taking over. So this taking over will be from a retrospective effect. Huh. Hmm. What is the difference between taken over and provincialization? Yes, mister, you have to say something. No, I'm taking up for final disposal. Let Mr. Buddha go come. It's okay. Then his part he can do whenever he comes. Okay. Because he is 86 years of age and I don't want to do again defer it. Something or the other will happen. It's okay. That's a short affidavit, short matter. He can always address. Yes. So, Kanan, who was the founder principal, what is the difference between taking over and provincialization?
Earlier past service will not be
Hmm.
that's what the government has taken personal go to the department
Hmm.
to give the retrospective effect. So that's a common model also.
So, retrospective effect to the provincialization as well.
Yes.
Hmm. Then?
So case 80.
Hmm. Hmm.
In partial motions, the department data that is 27 to 1998, that's in the case 16.
Hmm?
The governor
Hmm. 27 to wait 27 to is what? This is provincialization order. Hmm.
Taking for the program that the effect from 1
Mm.
1996, that is from the date of evidence decision on the basis of soil score.
Mm.
So that's so that the listener also
Gets the pension. Hmm.
Now the regulation order of the issue.
Hmm. Hmm.
In continuation of this department later dated so I am directed to state that the government of Assam is pleased to regulate the service of the following ex principal so model product where stating for that with effect from the date of as shown above their name. Even current model principal will effect from 1/1996 to 30/6/1996. So the police was regularized and taken over with effect from the 1/1996 to give the past service benefit. The prisoner's case was also accordingly regularized after her retirement. That is admitted. And accordingly, the prisoner's pension paper was forwarded case 20.
Okay.
Thereafter, since no action has been taken, the case 26, the prisoner submitted an replacement was pending. The activity also posed there that already for till now 10 weeks. It is a criminal circumstances. Also, was marked the Manosi motorcycle. Are expert counted case 32.
Manashi Bhattacharya, yes. Then
Case 32.
page 33. Hmm.
Thereby, the government has taken over a model of pizza telepolice to 1/96 and taking into the account of the appointment made by the governing body Mumbai area pizza telepolice. In respect of Srimati Manasi Gotteswar, the governor also seeks to regulate the services rendered by the Srimati Manasi Gotteswar. So and so as section to the PF from so and so for pensionary benefit.
But how come 83 here?
Initial appointment.
But in your case, your initial appointment was not, that was not taken.
But that's not taken. But in respect of the same police, the government has by invoking the rule 31 of the Assam Pension Act, given the benefit of in respect of the same police, same employee also, by this has been not.
That is your grievance.
Yes.
So your regulation was not made with effect from the date of joining. And it was only made with the effect for the effective date. So what problem?
Citizen has qualifying service for only 1 year. But in respect of the past service, that was not counted.
So then she is not liable for pension.
That is their.
But then her pension papers were forwarded.
Yes. Submitted our request.
That pension papers were forwarded, but it was not acted upon.
And case 25. Similarly, in respect of the four training colleges, they have supposed this honorable and on the basis of the government's instruction, also their case was disposed of. And thereafter, the government has passed order by taking over the considering their past service.
So petitioner's past services was not considered. So only to. So what is the purpose of giving her this? Right.
Yes.
To regularize her services from 1996.
70.
17.
It is 7.
Mm. Yes.
To give the benefit, irrespective of petitioner, and that now describe the
Will be entitled for pensionary benefits if the college are taken over with effect from so and so. But then it didn't.
for this also argument is 18 was
Huh.
that was the notification.
Taking over this college with effect from 96. But then that also will not be helpful for the petitioner because what? Regularized the services. So her regulation was done only from 1596, 1596 to 3697. So 1 year, 2 months, or 1 month, that will entitle her for pensionary benefits under the pension rules. No, she is regularized from 1/5. So she has 1 year of service. Huh.
Is
16. Yes. Huh.
there is no earlier past services. But by invoking the regulation 31, the subsequent order was passed, case 34, case 30.
Page 33. Yes. This is in respect of the other teacher.
The once
Huh. Because when the school.
that order was passed by invoking the
No, because when this notification was issued at page 16, Manushi was working. She was not the retired. She was not.
order was completely notified by
That is correct.
the case,
But then, yes, it was only to give her the benefit. But then it could not be. But what? Then they also somewhere in the rules, if you have 1 year of continuous service, you'll be entitled for pension.
31.
Pension rules kon diya na? Ekon. Pension manual. Hemenda. Ekon pension manual. Yes. Ekon. Boga nila. Yes. So, section, rule, whatever. Page 23. Yes. Huh.
Does not qualify to pension unless conforms to the following three conditions.
Mm.
Firstly, the service must be under government.
Hmm.
Secondly, the employment must be substantive and permanent.
Mm.
Thirdly, the service must be paid by government.
Mm.
Provided that we even to either of conditions so and so or should be declared that any specific kind of service rendered in non-gazetted person itself qualify for pension. The government has the power to invoke this.
No, somewhere I have seen 1 year continuous service. Where was that?
10 years. 10 years.
10 years. Where is that?
One woman, there's an office around the EPA 246.
246. Yes.
Is to sanction the payment of pension to the provisional consent is by relaxing the provision made under 31 for enabling entitlement of pension whose services have been provisioned under the Assam Portal and who are retired from service born after 1/10/91 plus serving more than 10 years and less than 20 years from the date of their equal appointment.
Okay. So what?
This allowable to living with the civil case.
That Justice Manisana's judgment. Oh. Achha. So what does the SCRT say? Only 1 year, 2 months continuous service in which she is not entitled.
That is paragraph 7. That is key page.
Propose to forward to Iman to the secretary by this for taking necessary action to relax the minimum qualifying service. Hmm. Hmm.
In fact, court recently directed against the order dated 22/9/2014, passed by the learned single bench, whereby also filed by the respondent litigation was accepted and the appearance stay was directed to count the services rendered by the respondent litigation as sub-register on commission basis prior to his regulation against the same course and to grant him the benefit under the Assam certificate. So in this case,
Hmm.
the case six number
Page 6, paragraph 6, yes. Hmm. 6 line, the period of service.
Service rendered by respondent from the date of registration, that is 25/4/2008 in his supervision, that's in 5 years.
Did not entitle him to pension. One requisite. Then what happened?
Paragraph 21.
Hmm.
Where to this discussion made here above, we are of the firm view that the learned single branch was actually justified in holding that the service rendered by the respondent for a period of almost 25 full years as a sub-register on commission basis, with effect from 28/4/1984, are required to be accounted for the purpose of completion of his pensionable service and all other considered terminable. Into judgment related to
Okay. So her past services was directed to be counted. Like in the case of Bhattacharya. Yes, Justice Manisanath. Hmm. Were similar.
Yeah. The death doesn't pay 31.
Hmm. Hmm. No, see, yes, of course, subject to what Mr. Buddha Gogoi or somebody say, that there was a decision so that she gets pension. But then the decision was not properly put, and she is unable to get the pension. But it could not be done because the qualifying service she doesn't have. Acha, where is that FR where qualifying length of service is 10 years for what? Where is that? What is that provision?
That's how I.
This is memorandum.
10 years service. Earlier 20 years was 10 years.
Okay, as per your affidavit, it says that she cannot because she has only 1 year some. Which, what? Your affidavit, only one. SCRT affidavit, yes. Yes, I've seen. She only had continued for this day, so she will not be entitled. Wait, I have not got that, miss. Yes. Which paragraph? Hmm. 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 No, she retired. She retired in 97, and then the provincialization of the college was after that, 98. And then it was given retrospective effect, the taking over. It was made from 96. But then she does not qualify for pension. But the intention for taking over was only to give her some relief. Annexure A, yes. Huh. It was taken over in 96, but then she does not qualify. So, but the fact remains it was for her benefit the entire exercise was done. Then if benefit cannot be given, then what is the purpose? So like the other similarly situated, let her also get the benefit. Why not give her pension? She has worked from 74 to 97. This is not fair enough. Shall I dictate the order? You are there? Acha, SCRT. Okay, I'll read his contentions. After he comes, I'll dictate the rest of the part. Okay, let him come. I'll just write his. SCRT affidavit. But she is the director of State Council of Research, SCRT. And then? Hmm? 17. Huh.
In the director of the SCRT,
Hmm? Hmm?
counter principle of the they have themselves admitted that the counter principle.
Counter principle, and she'll be entitled of any. Of course, if they dispute with these letters, I don't know. But then these letters shows that it's only for her pensionary benefits the college is taken over. That is a different issue because she was working when the provincialization order was passed. And in the provincialization order, it is said past service rendered prior to provincialization of at college, uh, taking over from 27 to 98, shall be counted for qualifying service. So her past service was counted. She actually is in a different footing. But what I'm on is because it is for the benefit of the petitioner that something was done. If it is not done, then what is the purpose? What is the. This should not be fair. Right. So, okay, heard Mr. K. Kolika, learned counsel for the petitioner, and Mr. whoever comes, and again, Badia, huh? And by this application filed under Article 226 of the Constitution of India, the petitioner has prayed for allowing her to give us it. Petitioner has prayed for counting her past services prior to the regularization, prior to the provincialization of the college or regularization of her service for providing her pensionary benefit by relaxing Rule 31 of the Assam Service Pension Rules 1969. The case of the petitioner is that the petitioner was appointed as a principal of Mongoldoi Teachers Training College, White order dated 25/4/1974. Achha. With effect from 1/5/1974. Thereafter, White order dated 11th of September 1998. The college, where she was appointed as a principal, was provincialized. With effect from 27/2/1998. The petitioner states that she had retired by then. More particularly, she retired on 30/5/1997. Full stop. It is stipulated in the said provincialization order that the past services of the principals and lecturer principal, principal and lecturer shall be counted as qualifying services for the purpose of pension and in the said notification, seven teaching and non-teaching staff were mentioned. Thereafter, on 3rd of September 2001, a letter was written by the director SCRT to the Commissioner and Secretary, Education Department, by which it was intimated that the petitioner, who was the founder principal of the said Mongoldoy Teacher Training College, will be entitled for pensionary benefits only if the college is taken over with effect from 1/5/1996. It was also intimated that if the taking over of the college was done from a retrospective date, that is from 1/5/1996, then an additional amount, which given them an amount of so and so, right? If retrospective benefit of taking over is to be given, an amount of so and so will be required. Given then an amount of rupees, an additional amount, an additional amount was required. An additional amount would be required. Pursuant to the said letter, a notification was issued on 7th of March 2005, wherein the governor of Assam is stated to have accorded approval for taking over the said college with effect from 1/5/1996. That is from the date of cabinet decision. In view of the said notification, the services of the petitioner was regularized as ex-principal of the college with effect from 1/5/96. 96, full stop. And that thereafter, the pension process had started and the principal issued a letter to the office of the Accountant General. But the same could not be processed in view of the lack of minimum service required for pensionary benefits. The learned counsel for the learned counsel for the petitioner submits that in case of similarly situated teachers, the services was regularized. Where is that? Bhattacharya? Page? From an earlier date for pensionary benefit. He submits that steps were taken for taking over the college from a retrospective date. Acha, wait. You disturb my dictation. Ki kono kosa? Steps were taken for the state for the coastal to taking over from a retrospective date only for the benefit of the petitioner so that she gets the pensionary benefits, comma, she being the founder of the said college, as reflected in the letter dated 3rd of September 2001. But due to lack of minimum service required, the petitioner could not be given the pensionary benefits. On the other hand, the learned counsel for the SCRT, by relying on the affidavit, submits that the petitioner had only 1 year, 2 months continuous service after her regularization, and as such, she is not entitled for the promotion, for the pensionary benefits. It is also stated that the petitioner was not the founder principal of the college. কি করলো প্রথম word was not the founder principal of the college as claimed by the petitioner, as she has been appointed as principal by the secretary only when the college was at the venture stage and not taken over by the government. It is also stated that the petitioner's services was regularized. Oh, no. It is also stated that when the college was provincialized, petitioner had already retired by then. And that although the services of the petitioner has been regularized with effect from 1/5/96, yet she is not entitled for the pensionary benefits. What do you say on Manisana's judgment? Mm-hmm. On the judgment of this, 1997, 91. Date of judgment is 91. Okay, rest of the order I'll dictate when Mr. Buddha comes. Tell him to come in the second half. Only if the NCRT sends, they will give. Let Mr. Big overcome. Rest of the part I'll dictate it in the second half.
Item 7.
Where is rule 31? 31 of this rule. 31 that you have just shown. Achha, okay. Data কি হয়? এইটো কি হয় আছে? আল্লাহ থকচোন মই এইটো ডাক্টেট কৰা আমাক। Yes, item 7, yes. Mediation failed. Mediation or what? Mediation failed. Failed. Any report? Last time it was sent, mediation report has been received. Mentioned failed. Okay. Yes. No affidavit Affidavit not required to be filed, Miss Borua, Miss, yes, by, so, Mr. S. Das is there. No, you are for elementary, higher. Secondary education is required. You Sharma was there today. I saw him. Okay. So, Mr. Perhaps they will file affidavit. Let me see the past orders. Instructions. Hmm. Okay, let him come then. Okay. After some time. Or in the second half, it's already one. Yes, Miss Terangpi. Instructions are there, I'm told. B. Kaushik was here in the morning and she's saying that instructions are in place. It has come. So, okay, in the second half. But 3:45, this court is rising. Huh? Tell them to come early. Okay. Yes. Oh. Acha, acha. Okay, Mr. Kaushik, you have the instructions, I'm told? Yes. Area salary. Okay. So, okay. Let them bring the final up-to-date status. Okay. If the relief can be granted this way, so why again? Hmm. Mr. B. Kaushik, learned standing counsel for the secondary education department, submits that the process before the government is going on, and that he should be given some time to place the latest instruction. Prayer is allowed. List this matter when. But area salary, be fast. Acha, for that particular period. He's otherwise retired. She's in service. Okay. List this matter on when? 12th of June. Will it be okay? Okay. 18th of June. Hmm? Item 12. Last time the conducting council has some personal difficulty and matter. Time was sought for. Acha. S- So now the council is not there. Item kimanito? 12. Mr. BK Das and H. Gogoi. None appeared for the petitioner on call. List this matter again on 8th of June. Not on record. Okay. Your Mr. R. Sensua, learned counsel for the petitioner, submits that he has filed an additional affidavit, but the same is not on record, and that he will verify with the registry and place in the records on the next date. List this matter again on Friday, that is 29th of May. Mm. Acha. Last order is very long order. Hmm.
That the earlier judgment as the director education has not taken any steps, and that is condemned.
Acha.
However, the earlier judgment refers to a judgment of 2007.
Acha.
Now that 2007 judgment has nullified our order, saying that we did not have the privilege.
Oh.
So perhaps there would be a question of whether we would be a competent authority to implement this order.
Acha.
So
So in that case, it is not contemptuous.
it would not. So
This is a contempt no read petition.
it's a repetition.
Okay, today the council is not there.
He was there. I informed him that I'll be taking that 10:30 he could not be here. And he just requested me to fix a date.
Okay, then okay. Mr. B. Kaushik, learn it. So you are taking time to get the again instructions.
Madam, Further steps, or June 6th.
Further steps in terms of the last order. Last order says what? To take steps.
Take some, to take remedial measures in terms of here.
Okay.
However, perhaps we file one application for the volume of this order to take an observation, which I expect is will be popular.
So you file an affidavit then?
Yes, no, I taken an application, but I have for the certified copy of the earlier. It's not.
Okay. So I'll just say that you will take some time to Mr. B. Kaushik, learned standing counsel for the secondary education, submits that he requires some time to get the necessary the up-to-date instructions as well as to file an interlocutory application if required. Prayer is allowed. List this matter on 16th of June. Okay. Then yes, 15. Petitioner in person. But it is not shown as petitioner in item 15. Acha. Okay. So what happened? Mm. Mm.
The last one, consider this petition and come to a conclusion.
It's your petition, your pension. And you have retired or what? No. Okay, let me go through paragraph 4. The present retreat and prior to that there were litigation wasn't here comments from Kolkata on every date of listing and this however considering the submissions made by the Shari and regarding the issue arising the present last chance which respondents consider return. So last chance was given Mr. Kaushik. By the last order, last chance was given to apprise this court about the final conclusion. Miss Mushahari was there. See the last order? Do you have? No. In the event, so in the last order, Miss Mushahari. Okay, Miss Mushahari is not there. Can it be taken up at 2? Okay, you stay back. You come from Kolkata, it seems. Acha, acha. Okay, something needs to be done today. Let's see what they say. Okay. Then? Yes. Mr. Mahmood, your matter is the next one, I guess. 16. So I'll take up after at 2 o'clock. After Miss Mushahari places the instruction or whoever, Mr. Khatunian. What about that half dictated matter? Yes. So, yes, Mr. Khatunian. Yes. The matter is about non-payment of salary. Disbursement of the final pension after your voluntary retirement with due reference and subject. Reference to any pension. So, do you have you seen this? Okay, okay. You go through this because what they are saying is it's okay. They want to give you the relief, but they had asked for the views from the pension department. So once they get their views, and they will process your or you go through this and then of course I'll have to give him some time so that he gets the views. The secondary department gets the views, school education department, and process your so uh, you go through this and then we will fix a date. Yeah, sure, you read it. Okay? Hmm. Hmm.
Government.
Hmm.
Not the depends on depends, pension depends on anything else. So it's not related. The government,
Hmm.
government should allow them.
No, yes. No, I mean, the decision will be taken by the government, not by the pension department. It is only that some views were asked for consideration of relaxation of the shortfall of the qualifying service. So this shortfall of your qualifying service will be considered by the government. Mm,
On the government, not by the government. Government has given the power over here. I'm talking about executive body.
mm.
Only government has the power.
Governor will, of course, that will be done by some authority, some secretary to the governor or somebody. So that will be done. That will be done. Don't worry. Okay. Also, Mr. Khatuniar, you expedite the process. But then the fact remains the pension department has to give you the views. So that will not take long. So their thing is very minimum actually. Actually, views by the pension department was not required. When you order, they will give you. Aha. Administrative reforms, training, and pension. So I'll fix a short date. Okay. Heard the petitioner in person. Mr. Mr. P. Khatunier, N.J. Khatunier, Learned Standing Counsel for the Department of School Education, has placed an instruction received in pursuance of the earlier order that is dated 31/3/2026, and the said instruction. And from the said instruction, it is revealed that the matter relating to regular pension of the petitioner in person has been referred to the Administrative Reforms Training, Pension and Public Grievance Department for Public Grievance Department for their views. And it is further stated that once the views are received, the claim for pension will be considered, and the relaxation of the shortfall in qualifying service under Rule 234 of the Assam Service Pension Rules 1969 would also be considered. Agota considered dilu niki? No. Would also be considered. As such, Mr. Khatunier prays for some time to get the full instruction from the department concerned. The prayer is allowed. List this matter on when you suggest a date. Hmm. Hmm. This is not only director of pension, this is administrative reforms, training, pension, and public grievance. Hmm. Hmm. Before. Yes.
Stop on 22nd.
What page number you wanted to show? Hmm. Hmm. But then you know how the government works actually. This is the way. Huh.
As for memo, they are SC 76,
Hmm.
1976, and the provisional pension has been forwarded
Hmm.
and should be receiving our pension, and this pension has been again, guys, this is ongoing process, Lordship, last 20 years.
Hmm.
So it is not that, Lordship, beyond the rule. It is in the memo, is there to simplification the pension.
Okay. On the next step, we will see what the views are, and then we will dispose of. Don't worry. We'll give you one last chance to him. Okay. So, prayer is allowed. List this matter.
Summary.
Hmm.
Lordship's court will start the summary. So
No,
if-
our summer vacation will start from 27th of this month. So we will fix it before that. Acha.
so after your
Second, not third week of July. So after reopening, then we'll fix it on 15th of July. 13th of. 13th is the opening day, 15th of July. 15th of July 2026. On which date Mr. Khatonia will place the necessary instructions without fail. And the matter will be taken up for final disposal. The said instruction is placed in the records. Yes, Sharma. Acha, Mr. B. Sharma, BJ Sharma, no, B. Sharma appears for respond number 7. And Miss D. Borgohai, Bor Pujari appears for respond number 10. 15th, we will decide. Will not make you come again here. Yes, it's a pleasant place. Enjoy this place. Stay here for some time. Oh, yes. Okay. Then you must be having your relatives, friends here. Enjoy. Item 3, Mr. Mahmood. Um, Oh, oh, yes, Mr. Bora. Hmm. Otherwise, you are correct. You are very correct. She has only 1 year something service. Hmm. 5. Hmm. Hmm. Of your affidavit. Yes, she had shown the rejection order by the. This is maybe after the rate is filed? Or no? No. 9/10/2012. This is by the accounts officer. It's okay, even if it is not filed or even if it is not challenged. Hmm. No, even if it is not challenged, the fact remains she is not getting pension, no. And this is rightly been rejected because she has very less qualifying service. But the fact remains, Mr. Bora, you go through this letter by the secretary. Only this is like disturbing me. Page number 17, you go through. Huh. Last paragraph, see, it is for her benefit that this decision was taken. So if it is not granted, then what is the purpose of taking this decision? So what I'm thinking is, she will write a letter. You please consider on the basis of this. Okay, Director of Education, I'll give that order to him. This is otherwise NCRT. On the basis of this letter, the director will decide. Otherwise, yes, this letter I've seen. Initially appointed as so and so, so and so. It has been mentioned that training college has been taken over in 96. Hmm. Hmm. Where? Hmm. 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 So, okay, Commissioner and Secretary will take a call. So, okay, he will make a representation or by something. So, her service should be taken into account from a retrospective date, like other similarly situated teachers. Because others are given, although others are in a different footing. She did not retire when this provincialization order was issued. A judgment she has placed. So consider in the light of this judgment and this. Okay, কি করছিল এখানে? 96. সেইখিনিতো সিহঁতৰ submission করলো ন? Yes. Yes, Mr. Bora বুলি দি দিবা. Mr. S. Bora. And Para. As far as the contention of the state respondents are concerned, the same is not incorrect in view of the same, in view of the fact that petitioner service was regularized from 1/5/1996. That is the date when the college was taken over by the government of Assam. However, by applying the said date, the petitioner does not become eligible for the pension in view of what? Rule 31? In view of rule of what? Rule 31 of the Assam Services Pension Rules 1969, wherein it is provided that minimum of 10 years service is required, right? 10 years of qualifying service is required. However, it should not be lost sight of the fact that the undersecretary to the light of the fact that the director of SCRT by letter dated 3rd of September 2001 had communicated to the Commissioner and Secretary to the Government of Assam, Education Elementary Department, that the petitioner was the founder principal of Mongoldoy Teacher Training College. Although according to the respondents, it was a venture school then. But it was further decided. No, although she was the founder teacher. No, প্রথমতে কি বলি বলো? Wherein it was communicated, no, that petitioner, but for according her pensionary benefits, the taking over date of the college by the government was recommended to be from a retrospective date, that is 1/5/96. And in pursuance to that letter, the taking over was done with effect from 1/5/96. Full stop. However, even if the said retrospective date was fixed, but petitioner could not be given pensionary benefits due to minimum length of service. It is also seen that in respect of another principal, she was also the principal or teacher, lecturer, in respect of another lecturer who had also retired, but after provincialization, the regularization in respect of her service. However, in respect of another teacher, detail respect na lagi. Regularization of her service was done with effect from 93, right? Page 32. Manashi is done with effect from page 32. With effect from 21/11/1983. And as such, she was eligible for receipt of the pensionary benefits. Further, the judgment placed by the learned counsel for the petitioner, rendered by this court in writ appeal number 73 of 2019, it was stated, which paragraph you had shown? stated, no, rendered in so and so, on a similar facts, stated, held, which is the operative paragraph is, huh? 21. Held that the appellant in the said case had rendered a service of 24 years as a sub-registrar on commission basis, and the same was directed to be accounted for the purpose of computation of his pensionable service and all other consequential benefits. As such, this court what should I tell them to consider, or by virtue of this decision? Okay, let them consider, fix a date. Otherwise, date is not fixed. As such, this court deems it fit to direct the secretary, of commissioner and secretary, to direct the commissioner and secretary to the Government of Assam Education Department, Elementary Education Department. Oh, Department of School Education, huh? Department of School Education to consider taking into account the past services, by taking into account the past services rendered by the petitioner as a principal of Mongoldoi Government Teacher Training College from the date of her appointment, that is in the year 1993, right? Oh, date of the appointment. Oh, 93 ভুল কৈছো। Date of her appointment with effect from 1/5/1974, and consequently, appointment till the date of her retirement, and consequently allow the petitioner her pension and pensionary benefits. It is further directed that the concerned authority would consider the case within a period of 1 month from the date of receipt of the order. Nothing much, no? She will get pension. Acha, yeah, no. I mean, she is getting provisional pension. Oh, no, nothing. No, nothing. So, nothing. She is not getting anything. Okay, make it 2 months. 1 month she will survive. Yes, 2 months from the date of receipt of this order. Disposed of. Yes, Mr. Mahmood. Additional affidavit? Respond number 1 to 3 would file additional affidavit. Where are the respondents? Who is appearing? Secondary education. Secondary education, Ms. Mushahari, you are there? I allotted to you. Do it. So, secondary education is respond number 1, 2. Principal in charge, what will happen? Service is complete. No, first of all, if the respondents are all served and pleadings are complete, I can take up. There are few private respondents also. Deepak Kumar, hello. You are not claiming any relief against them. Then why did you make them a party?
And then I.
Acha. Huh. H. Terangpi appeared last time. She was here. But on the last occasion, she took time to file an additional affidavit. Call her. Miss Terangpi. Yes, Mr. Mahmood, you can proceed. Huh. You have said that private respondents have not come and they are not required. I'll just see the office notes. Affidavit regarding Dusty has been received, so they are served. Yes, Miss Terangpi. Last occasion you had taken. You take time, somebody else come, someone else will file the affidavit. Who? D does. P stands for? Oh, Priyanki does. She was here in the morning. So whether without the affidavit, I can hear this matter. Yes, they have filed, but an additional affidavit. Bringing on record what? So ask her. She is not there in the court. Hmm? 21, he was suspended. I'll take up Mr. Tarangpi. Okay. You see the affidavit? Yes. Hmm.
High School, the district of Kachar.
You are appointed as what?
Hmm. Just 15.
Page 15. Hmm. Hmm. Sri Chan Mohammed. He is the petitioner. Appointed as his assistant language teacher. Okay, so and so, yes. Against regular vacancy. Under the rule for 3 months. 3 F appointees. No, no. Is it 3 F appointees? Acha. Then?
Only so request Sri Chan Mohammed, assistant teacher of Park Vidyapit High School, Ogani Bajar of Kasai District Government transferred and posted in Pukradar High School, pursued Pukradar Novel District, at the grade scale of grade educated. I Sri Govinda Kumar Mohammed adjusted against the second post of assistant teacher. Thereafter, when I went to drain, some problem was created by drains. I informed the matter to the IX. And it's 19.
So he was transferred to Kachar, right?
From Kachar to Gauhati.
He was transferred and posted in Khograpar. Okay, then?
Then online. I was felt some disturbance in my joining. Then I informed the matter to IX. That kind of secret 19. With reference to the
As the post has been already filled up, so he was not allowed to join.
I was contacted the authority. Thereafter, so I was allowed to join. I was allowed to join. The proximate agency where 19 over the next 21.
21. I'm really if her appointment has been reported, no, it has been reported. Type copy. Yes, it has been reported by Chan Mohammed, who was transferred. High school not received. Why does he could not join in some release from so and so and this is the same letter that I have just read. Yes.
Then, 21 I was allowed to join. 21 I was allowed to join. Then I informed the matter to the IX. 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 Then I informed the matter to the
22. Hmm?
Then what can you say? A
Retransferred and allowed to join against vacant post of Barajal High School. Because he could not be adjusted there, so he was taken to another school. Okay.
on 23rd can say,
Hmm.
done Mohammed, which is by
Hmm. Principal.
suspension or
Barajal. Oh, principal.
uh,
Achanma himself.
yeah,
Himself.
Assembly should not upgrade it. District government are allowed to hold the charge of principal of the school,
Hmm.
right? Subsequently, it has come to light that John Mohammed himself prepared the celebrity list of teachers
Hmm.
of the school
Hmm.
and signed the same on so day. As for insert principal under the authority, which is an unlawful activity on the part of the department proceeding is for our the
Hmm.
better. As suspending trial of department proceeding, John Mohammed
He is placed under suspension. Okay. He will receive subsistence allowance. Then?
then Russian mechanism is
Hmm.
until further orders, John Mohammed will be a resident teacher of Baradar High Secondary School. Normally hereby allowed to hold such charge of principal of same school along with financial power to draw and disburse the salary except of the staff of the school.
This order was before his suspension.
Then Russian say,
Because see, 26(7) is the suspension order, and this is 1st of July.
as the vice
Hmm. Where?
that Russian can do that by the
One annual increment was imposed. Stoppage of one annual increment.
again.
Okay, he is reinstated in service.
In the original post of resident teacher of Baradar High School
Hmm.
with immediate effect.
Hmm.
So that was done.
Hmm.
Then we will assign the distribution
Hmm.
or some area select.
Hmm.
And that was finally disposed of
Hmm.
with the dispatch 30. Did you?
Oh, it has become infractuous.
So, but my grievances were not addressed.
Oh no, it was it was addressed by the department. During the appendice, after considering the inquiry report without prejudice against so and so, reinstated as in so and so.
Whatever was filed, the review was not properly provided.
Hmm.
And my salary was also not provided, it will be given.
Hmm.
That's why I wrote the letter, that is page 31. Last where I will give, therefore I pray that your order.
Where? Yes. Prayer for release. Okay, then.
This is my prayer and this is my annual increment so that I may renew my service as annual without any struggle.
But one annual increment was stopped. Right.
Then my lord,
One second, one second. One second. I have done anything intentionally. Annual in 22. But how can you again, demand your annual increment? Your one annual increment was stopped. In the same year, 2022, you write a letter. What? This is when?
36 yes,
Huh?
36.
Okay, 36.
They said that there is no fund. So with reference to the subject, I have to submit survey. The statement of requirement of fund for the payment of retail salary from 1/9/2004 to 20/2006 of the Salvova, Asian teacher, Baradar High School,
So
Hmm.
this letter was written by the headmaster to the director.
Area salary with effect from 2004 to 6.
That was not provided on the ground that there is no fund. So the headmaster.
When was the suspension order issued?
Suspension order that is page
21. No. Yes. It was in the year 21. And this fund for area salary from 1/9/2004 to 2006. Why is this salary not paid during that period?
that saying that at that time there was no fund. It is the statement, it is the saying of the
Fund here now it is fund. Now it is scarcity of fund for payment of area salary. But why was this salary during this period not paid to you? 2006. 2006. That was long back.
eight.
Hmm?
Eight of credit.
Page 8. Okay. Hmm.
From the top, second line, then the petitioner is naturally attended to getting instrument to give in the period where the petitioner was unrestricted as a suspension.
A suspension was in the period to 2021.
Yeah, yeah, and
No, no, you first answer my question. Why was this salary not paid? Why this salary was not paid during this 1/9/2004 to 28/2/2006? Your suspension, everything was in 2021.
but that was their case there. At that time, they had no fund that I have mentioned. But no letter is published to you. But in the petition I have mentioned. That is a very second one.
And this was a letter of 2007. This was not after all the suspension reinstatement. This is 2000, this is long back.
Six, 2007.
Hmm. This was the huh.
Six months was a letter when I demanded that this period of salary I did not pay. Get the principal wrote letter to director, the kindly furnish the fund.
This was in the year 2006-7.
That one was where I was paying, but they did not give.
What is your grievance now?
I mean, of that period. That is from 26, 8, 11. That is December 2004
Huh.
to February 2006.
Huh.
This period salary plus the period of suspension. These are the two players. I made it very clear.
See, your case was you were put into suspension, then inquiry took place, and inquiry officer suggested that 1 year increment will be stopped, and so that was done, and then you are reinstated. Now you are talking of your area salary of 2004 to 6. Now you are saying, now you are by this petition, now you are asking for this area salary.
I thought that this.
You did not approach the authorities 2000. Then what happened? You did not file court case. Court case you did not file.
If I find earlier, so that is possible.
Yes, Miss Terangpi, if you have answer to this. See, some salary was not paid for 2 years in 2004 to 2006. And the principal headmaster had written a letter to the director that give me funds for payment. That was in 2007. After that, what happened? Now we are in 2026. 21, there was an inquiry and then he was reinstated. So he is mixing up both. 2007 and then. So what? 2007 is a long period. Now what happened then?
That was not paid. In the meanwhile, my suspension period salary was.
What have you written in the affidavit about this 2007? After that, what happened? Director must have replied something had happened. This 2007. Mr. Mahmood is unable to answer. But after so many years, you have come for what? Your what is a prayer? Let me see. petitioner shall not be paid the annual increment which was due during the period when he was unjustly kept under suspension. It was not unjustly kept under suspension. You were imposed a punishment. It was not that you were reinstated for dismissal of the inquiry. No.
delay.
Hmm.
It's just 38, but today I am receiving a reference also. It is a finding of the inspector who is the inquiry officer.
Huh.
From the above statement, it is clear that Sri Torun Bormo misled San Mohammed to which the whole incident occurred and gave a bad reputation to the department.
Whatever it is, you should not have prepared the select seniority list yourself and signed it. Maybe you were misled. Why did you get misled? People will try to mislead you. You'll get misled. So this is, but then what join newly? You have been in the service for long. So what? You don't know about senior advocates' ways when you are not. So you will know. You will know what is the duties of a principal, vice principal. Yes, inquiry report was given and it was suggested that one increment will be stopped. Right. And so that was done. And after that, you were reinstated. Hmm. Okay. Hmm.
My suspension was not valid.
No. That is not the case. What suspension not valid? Your suspension was valid. You were found guilty and a punishment was imposed. Thereafter, you were reinstated because it was not a major punishment. It was a minor punishment of stopping 1 year increment. So what happened? Your prayer is should not be paid the annual increment. Why will the annual increment be paid? It was stopped.
1 year, that depends, then I will get passport.
The later increment you will get. The petitioner shall not be paid the wait. I'm seeing your salary prayer. Shall not be made the area salaries from 21 to 22. You are paid subsistence allowance.
Yes.
And then it's not that you were held not guilty. You were held guilty. So why will you get the area salaries? Shall not be paid for area salaries from so and so purportedly directed as manner to bring him in original post at so and so. So many prayers to appoint the petitioner as next in charge principal of so and so. Page number 38 is the inquiry report.
At least inquiry. Details inquiry report. That was the idea of a foreign border. They were assisted. So what he misled me, of course, I should have been thinking, more careful. Again,
You do one thing, you file an application, representation before the authorities. Have you made any representation?
yes.
Where is that? Heard Mr. M.U. Mahmood, learned counsel for the petitioner, and Ms. H. Terangpi, learned standing counsel for secondary education. You are also there, Pavitra Saikya? No, no, sorry. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for
Yes.
prayed for uh, a writ of mandamus directing the authorities to pay.
The period of suspension, that by fundamental right. There is no one in except one increment. So that period some mandamus may be issued. And rest of the matter of 2006 to.
Now, what is the law like? You are paid subsistence.
Person, the suspension I have given mistake.
No, suspension is not revoked. It was suggested, and then, in fact, your disciplinary proceeding has not come to an end. What about your disciplinary proceeding?
Ended because.
Why will we treat as ended? There will
Then later.
no disciplinary proceeding has not ended.
Pending for incident.
But then you see, whatever you have annexed, your increment was stopped without prejudice, to the continuance of the disciplinary proceeding. Where did I see? I saw it somewhere. As such, yes, as such, a pending withdrawal of departmental proceeding. Oh, without page 27, without prejudice to the ongoing departmental proceeding, you were reinstated.
Then
You were placed under suspension. You were given subsistence allowance. Departmental proceeding was initiated. Inquiry officer gave the report and he suggested, it is not his final, of course, it cannot be a final report. He suggested, wait, listen here. He suggested for imposition of one punishment, one increment. After that, it was pending. What happened to that? Bring the necessary information.
so yes, not extended. No order is no word, no sub order. Normally within 90 days, suspension should be disposed of.
Mm.
Thereafter, if they authority wants to extend the period, they should issue fresh order.
Fresh order. Now, what happened, Mr. Rampe? Do you have any information? What happened to disciplinary proceeding? It's ended. No, it has to end. Otherwise, 90 days period, it has to end. So you make one, I'll write these facts, make one application before the secretary, and he will consider. Giving you the salary for 2006-7 and for whatever.
And with salaries, that extending substances allowed other salaries. And
You will not get whatever you have asked for. He will consider and he will give it to you. Mhm. Because things are not clear whether it has ended, what happened, whether he was given the inquiry report, all those things will be required.
that there is no validity now, it is now. First, 21, we are in.
You never know. It must have ended with some more punishments. What we don't know. We don't know. You have also not annexed. They also do not know. So you make an application. Hmm. Okay. Kolu no? Ki kolo? For a prayer, mandamus, directing the authorities to pay the annual increment. No. Pay the arrear salaries from 26/7/2021 to 22/12/2022, as well as past arrear salaries from 1/12/2004 to 28/2/2006. And also with the prayer to appoint him as in charge principal of Barazol Higher Secondary School till a regular principal is appointed. The case of the petitioner is that he was appointed as an assistant teacher in Bam Vidyapit High School by order dated 28th of May 1992. Full stop. Thereafter, he was transferred and posted in Ghagrapar High School, Nalbari, by order dated 8th of October 1998. However, the petitioner states that he went to join the said school of Ghagrapar High School, the said school, namely Ghagrapar High School, but he could not join in the said post of assistant teacher in the said school, since the post to which he was transferred and posted was already filled up. And as such, the Director of Secondary Education Assam, by a letter to the Inspector of Schools Nalbari, requested to adjust the petitioner in some vacant post of assistant teacher. Thereafter, the petitioner was allowed to join against the vacant post of assistant teacher in Borazal High School by order dated 22/5/2006. Full stop. While the petitioner was working as the assistant teacher, thereafter, the petitioner was allowed to hold the principal in charge, allowed to hold the post of principal in charge in Borazal High School, but while he was working as in charge principal, a misconduct in Borazal Higher Secondary School, a misconduct was noticed to the effect that he himself prepared the seniority list of the teachers of the school and signed the same on 19/4/2021 without any authority. For the said alleged misconduct, a departmental proceeding was called for. And during the pendency of the departmental proceeding, the petitioner was placed under suspension and he was allowed to receive the subsistence allowance by order dated 26/7/2021. আচ্ছা আচ্ছা এই যে ওপৰত যে লিখিলো he was allowed to hold the post of in charge principal, তাতে তুমি লিখি দিয়া by order dated 1st of July 21. 1st of July 21. It is the further case of the petitioner that during the pendency of the departmental proceeding, the inquiry officer submitted an inquiry report on 28/4/2022, wherein a suggestion was made for imposing punishment of stoppage of 1 annual increment upon the petitioner. And on the basis of the said suggestion, 1 annual increment was stopped and without prejudice to the ongoing departmental proceeding, the petitioner was reinstated in his service in his original post of assistant teacher of Barazal Higher Secondary School. The learned counsel for the petitioner submits that the petitioner being reinstated in his service in the original post of assistant teacher his area salary should have been paid. And that his subsequent annual increment should also be released to him after his reinstatement. Oh, no, it will released to him. Being allegedly aggrieved, the petitioner submitted a representation before the Director of Secondary Education Assam on date is not there. Huh? No date. Undated bill detail, which was undated. The petitioner has further. That is that letter, 22/12/2022 letter. That is the reinstatement order. The learned counsel for the petitioner further submits that the petitioner was not paid his arrear salary from 1/9/2004 to 28/2/2006, and that he has placed a letter written by the headmaster to the Director of Secondary Education Assam
112.
But here in this letter, it was 19. 19. Where is 112? Your prayer. 112. 1/12/2004. You are leaving 3 months salary. Why leave 3 months salary? Principal has written from September to February 2006, right?
I think 3 months minus September, October, November, December.
Hmm.
3 months she has gone. So what the
3 months when did she get?
3 months salary was paid to me.
Where is that? How did you know? That is 2004. 2004 to 6, there is nothing on record. Why?
Some people
That is why I'm saying, ki kulo. Secondary Education Assam, wherein the headmaster requested for funds for payment of arrear salary to the petitioner. That is from 1/9/2004 to 28/2/2006. It is also the case of the petitioner that in the inquiry report, it was stated that petitioner had done the alleged misconduct on being misled by one Torun Bormon, who was working as what? Torun Bormon? Who was working as the senior assistant of Inspector of School, Inspector of Schools, NDC, Nalbari. What is there in the affidavit?
Well, they say that the suppression will work, will not have that. There is no force in their.
There are so many. Dusty service.
They have annexed certain by representations in page 56, 57. Actually, those copies were not furnished because furnished to the authority without giving the copy. So this said, yeah, page 60.
Acha, your inquiry report has, inquiry has ended. See there, Annexure 8, page 78.
Page 56 and 57 by presentation.
No, see page 78 of their affidavit. Yes, affidavit, continuing page 78. Conclusion, page 79. Is concluded, departmental proceeding concluded by imposing punishment of so-and-so with cumulative effect may be reinstated in his original post of Iman India so-and-so by regularizing the period of service. Suspension only for pensionary benefits. So if only for pensionary benefits, you will not get the salary for those period. See page 79. No, their affidavit. In their affidavit, Annexure 8. This is affidavit by respond number 2. Hmm? What 59? Yes. Acha, okay. 59 is actually the first page of their affidavit. Annexure 8 is 78. See Annexure 8, okay. Perhaps you are showing. No, it's okay. See Annexure 8. I think the same page you are holding. Annexure 8, there you see the conclusion. For pecuniary gain by putting his signature on the seniority list by using the word for on behalf of the principal for holding the charge of so and therefore guilty on the part of Chan Muhammad is found. So you are found guilty. Then accordingly department proceeding drawn up of so and so school may be concluded by imposing punishment of stoppage, same thing. Moreover, Chan Muhammad may be reinstated in his service. Okay, did I episode likha? No, see. Moreover, Chan Muhammad may be reinstated in service in original post of assistant teacher by regularizing the period of suspension only for pensionary benefits. You will not get the salary. Only for pensionary benefits, your suspension period was regularized. No, you have not challenged his inquiry report. You have not challenged your punishment. So it attained finality. Why? Copy will be, it's an affidavit. It has been furnished. So it is furnished to you. No, if the report of the inquiry officer is not given to you, you could have come to the High Court. It is not there.
However,
and hearing of the Inspector Chan Muhammad, you were also there in the inquiry. Right.
Yeah, but if order was from the
So as far as increment for other period, you pay, and for your salary from 2007, 2006, 7, you make an application before the authorities, and then I will say on the above facts they will consider. Hmm. On the other hand, the respondent number 2 has filed an affidavit. বাদ দিয়া আহিব। Huh. Not required. It is paradia. It is further seen
alia. So if any query is there, that will be considered.
Yeah, yes, but then you have to be served with an inquiry report, Ramzan Khan, Ramzan Ali, or whatever. So here, if it is not provided to you, you have a cause of action to have challenge. But then this was in 2022.
Is that 100%, that if the person concerned can be able to this case, even if not prepared, he does an applicant.
Okay, you make the representation, they will see, huh? In the কি বুলি কয়, last খিনি কি হয়? Huh? It is further stated that that in the report of the inquiry officer, it is seen that the petitioner was held guilty and the department proceeding was concluded and a minimum punishment of stoppage of 1 annual increment with cumulative effect was imposed upon him. It is further noticed that these services of the petitioner no, you say it is further it is further stated that while reinstating the petitioner in his original post of assistant teacher in Borazol Higher Secondary School, the period of suspension was regularized, but the same was only for pensionary benefits.
Proposed not punished.
Those are not in pleading now. You don't even know you, but the learned counsel for the petitioner submits that the copy of the inquiry report was not furnished to him. You have not taken action after that. You should be vigilant enough. In the facts and circumstances of the case, the petitioner is as such directed to submit a representation before the Secretary, Government of Assam, School Education, bringing into his notice the said facts and for release of his arrear salary for the period from where is that letter?
Yes, 31.
From 1/9/2004 to 28/2/2006. As it is not known what happened after the headmaster wrote the letter to the Director of Secondary Education. requesting for funds. With further prayer for awarding the annual increment for the subsequent years. Petition is disposed of. You make those. The concerned authority may dispose of the representation submitted by him within a period of 2 months from the date of receipt of this order. Yes, Mr. Saikya, you have your matter. Ki? কোনটো matter? এটা হোৱাই নাই নহয় 21/5 কেলে এইবোৰ হেৰি নাই হোৱা yes. Now what is this matter called? Oh, 17, yes. Petition is disposed of, huh? Juhi, petition is disposed of, লিখি দিবা yes. He will file an affidavit by 10/12. Acha. 25 only. Acha, the respondents are represented. Secondary education. And what about inspector? You were appearing. The inspector. Managing committee of the school? Not represented. No, he said not required. They are supporting. And so 1, 2, 3, you are representing. So you have filed your affidavit, you are ready. Achha. Yes, Mr. Saikya. Okay, Mr. Saikya, let him know. Yes. Page. Anwara Begum has decided to allow her to do the classes. What kind of an appointment order? Resolution. Earlier, there were no higher secondary scheme. It was a 10th high school. Peradhora. 1992. But it is required in only 11 and 12, higher secondary part, yes. So that subject was not there. Achha. Director. This is a prayer for sanctioning the post of education. After that, what happened? It was not sanctioned. Hmm. 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 In the year 2015, yes. 20th June, Annexure 5. Again, prayer is made for sanctioning. Allotment? Hmm. Yes. Hmm. Yes. So the enrollment of the student is okay as per the, because 10 students required. Hmm. Hmm. Yes. Hmm. Passed. This is only in respect of education subject. Neither the post was sanctioned, nor she was regularized. No salary means some consolidated something is paid. Fixed pay. Hmm. Hmm. Yes. Hmm. 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 Okay, I've read. So she should be given weightage and all if she appears. Okay. Hmm. So what happened after the High Court's order? Oh. So the post is sanctioned. Huh. That was also a direction to decide the aspect and pass a region order, necessity of sanctioning a post. Hmm. Arre. It is known that she is working in a non-sanctioned post. Post is not sanctioned. High Court ordered. Hmm. Hmm. But the fact remains she is continuing in a non-sanctioned post. Hmm. And she was appointed also by due procedure. There was an advertisement. There was a resolution. Yes, yes, that I've seen. So show me the judgment. Hmm. Hmm. Yes. Paragraph. Oh, you are giving many decisions. 3. Paragraph 9. Yes, it is admitted fact that all the respondents are continuously working as teacher and the salaries are being paid by virtue of are not being paid. When the respondent continuously serving as a teacher, the question whether they are appointed or otherwise they matter less. However, for the services available by the state on the principle, in view of we find no ground to interfere. Okay. So their salaries has to be paid. Then Gobindra Kumar. Oh, this is my judgment. It's okay. Then, hmm, this is Masanta Borman. Hmm, hmm, yes. Hmm. The problem is that I'm rising at 3:30, 3:45. I have a bench. But then I'll have to hear them. Not some other day means tomorrow. Hmm. Hmm. These are your judgments. Hmm. Okay, it's okay. Dharam Singh. Okay, I'll take it up tomorrow then again. Jaco, to I've seen. Jago is for regularization. Hmm. 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 Oh, once they have allowed the person to work for so many years, and there has been a High Court's order, they have not followed that. They have not sanctioned in spite of so many efforts. Miss Piras, you can finish it if we can finish it in 10 minutes. These are on regularization and non-payment of salary. No, not Monday, tomorrow. Tomorrow. Friday, this court will not be there. Huh? No, you can start. I have some time. You can start. No, you already have your affidavit. Yeah, affidavit is 2 pages. See? Was appointed as a so-and-so. Wide SMC. Mhm. Hmm. There is nothing in your affidavit, only that she was appointed on an honorary basis and then her case was rejected. Nothing.
Is authorized or competent to appoint any teaching or non-teaching staff, your lordship. Your lordship, memorandum has already been issued, your lordship.
Where memorandum?
By 660 per time.
60. No, 60 is not the relevant page. Affidavit, which paragraph? Paragraph 5, I've seen, yes. Decision of the school management committee of. Mhm.
contravention with government of this memorandum which is issued by ASC.
Acha, this memorandum have you annexed? What is this order, Mr. Saikya, dated 14/3/24? Hmm. Hmm. Acha, this was after the High Court's order. Director had written to the have given us such. Hmm. This is the same impugn order which he has challenged. Okay, I'll dictate the order tomorrow then. Tomorrow as the first item at 10:30. No, 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 I'll not postpone this matter tomorrow for dictation of the order at 10:30. Because I don't want to dictate it in the chamber. In your presence, I might go somewhere wrong. I think it isn't. This will be enough. Okay. Has he listened to the recent judgment? Yes, Miss. But then 3:45 we have a bench. So I'll have to sign the orders again. 4:45 we have a meeting. Not tomorrow. It's okay. Short matter. All matters are short. But then not tomorrow. Next week. Okay. You speak to the court master. He'll give you the dates. Acha, Mr. Borbia, did you as prayed for by the learned counsel for the parties, list this matter on 2nd of June. 2nd of June. 19. Which matter? Barbia's matter. Hey, after vacation will be too long. On 2nd of June, he said it's a small matter, let it be disposed of. Yes, mister? No, no, Miss Chaudhry's. Item 19, what happened? Oh, item 19, as prayed for by Miss S.B. Chaudhry, learned counsel for petitioner, placed this matter on 4th of June. 4th of June. You remind me, I'll take it up. 26 and 27, it's a hearing matter. Okay, as prayed for by the parties, 4th of June. 4th of June में बहुत है क्या? अच्छा. अच्छा, 3rd June. 33. 33 list, Mr. Das is there. As prayed for by Mr. Sensua, learned counsel for the petitioner, list this matter on 10th. 10th of June. Oh, the K. Muhammad, yes. Sorry. 22 and 25 are did, yeah? 11th of June. Acha, wait. 11th of June will do? Yes. Yes. 21, you give a fixed date? Give out a date, did you? 10th of June. Yes. It dispose of. Can you call him? Oh, order to demolish now. Which one? Mr. Sekya's matter. Partly heard. List this matter again tomorrow. Your matter as a first item. Yes.
Waiting for a second. Last time I need to go to the
17 है और 17 before 1917
अरे वही बनेगी ओ सर
तीन तारीख दे 24 तीन
ओ,
तारीख